Part 2 matter hearing list. But the matter is of 1962. Our lands were acquired. Till today, compensation not paid. So we mentioned in court number 10 the other day. Said it was said that mentioned it before that.
Of this fan. A fan offer. Yes.
Mentioned it before the appropriate bench. That's why I have approached before lordship.
Part 2 item.
Part 2 item, but it should be listed in part 1 in hearing list, and that was agreed already. But your lordship directed me to raise the matter before your lordship, and we have got this case upgraded after filing case.
Part 2, which case?
89, item 89.
Have you got? Give me the part 2 list. Where is the part 2 list? Contempt.
No, land acquisition matter.
Huh?
Land acquisition matter.
I don't have 89 here. 89 is a contempt case.
No, it is bench.
I don't know. You look at your cause list. Yes.
Lordship, I beg to mention item 19. On
Item
19. So
19.
Kumar Das versus Hindustan Petroleum.
Yes.
Somebody demise in the family of senior advocate Jain Sahewala sir,
Okay.
who is representing respondent 4 to 7. So kindly list the matter after a week.
Okay, right. On the prayer for adjournment on behalf of on the prayer for adjournment on behalf of Mr. Jain Sahewala, learned counsel for the respondent number 4 to 7, on the ground that you put this off also. On the ground that there has been bereavement in the family, list the matter after a week.
Lordship, meanwhile, interim may be continued.
Interim order to continue till the next day. Have you spoken to the other side?
Yes, Lordship.
Spoken to Mr. B.D. Das?
Yes.
Okay.
May I please, your lordship, may I pray for listing of a motion matter day after tomorrow, your lordship? Motion
What
matter,
is the matter about?
matter, your lordship, it's an order by the Register of Cooperative Society, your lordship. 3, your lordship, the petitioners, 3 in number, they were incorporated as the directors of the Cooperative Society, your lordship. That order was challenged, your lordship. And the Register of Cooperative Society passed an order without hearing us, your lordship. Now next meeting will be order passed. Next meeting will be held, your lordship, on 18th, your lordship. Therefore, your lordship, we have some urgency.
18th is enough time, Mr. Counsel.
No, your lordship, we will have to issue, they will have to, you will have issue at any time. 18 is the last date for holding the meeting. And at any time they can held the meeting. Your lordship.
Okay.
Deeply obliged.
Yeah, please, your lordship.
No, I have-
Beg to
I am-
for item 18 of today's list.
Item 18, yes, madam.
Senior is not well.
Who?
SK Talukdar, Corporation Department.
Okay, right. On the prayer for adjournment made on behalf of Mr. His name is not here. Item 18.
Yes.
18 of part 1.
Yes, on behalf of Corporation Department, Cooperative Department, Mr. SK Talukdar.
Maybe, but then
Item 18, they have mentioned him on behalf of Cooperative Society.
okay, so you are for the petitioner?
Petitioner.
Okay, right. On the prayer for adjournment made on behalf of Mr. S.K. Talukdar, learned counsel for the cooperative department, who is apparently unwell, list the matter after a week. After 2 weeks, what? After 20 weeks, what? After 2 weeks.
I have I am Millard for calling out some records for the court below Millard.
Huh?
That it was also listed on last Millard 3-5, but not listed.
You go to the registry.
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 May I please, Your Lordship? My lord, this matter, my lord, relates to, my lord, vehicle requisition fees, my lord. So that has been, my lord, taken away by the respondent, my lord, fraudulently, my lord.
No, is it a pending matter?
Pending
You
matter.
go to the registry, go there and apply, go there and ask for listing.
May I please, Your Lordship, I beg to mention for listing for pending contempt petition.
Go to the registry.
May I please, your lordship, I beg for the listing of 2 matters, your lordship. One is an interlocutory application in connection with the writ petition civil of 1843 of 2023, And
Has it been listed earlier?
no, your lordship, the interlocutory application has not been listed earlier.
When was it filed?
It was filed in interlocutory application was filed in 20 April of 2023. There is an aspect of continuation of delay, your lordship. There is already been a delay of 1 year, so we seek that this matter be posted tomorrow on 10th.
Day after?
Day after tomorrow will also be fine, your lordship. And there is another case of contempt case civil of 203 of 2023. The matter was.
That is a new case.
Yes, it was once listed on 5th of April 2023 during the Platinum Jubilee celebrations. Due to some personal difficulties, the petitioner, the counsel for the petitioner could not be present, moved the matter. So, and as such, the condition now is that.
What was the order passed in that case?
The order passed was that the petitioners can prefer an appeal before the respondent.
No, what was the order passed on 5th?
I beg.
Yes, what is the other case? You come this side, some of you. Yes, what is your case? What do you want?
My lord, I beg to mention item number 8, my lord.
Yes,
I'm appealing for a review applicant, my lord.
yes.
Senior, he's out of station, my lord, today, Mr. Chamaria, my lord. So I pray for some time.
You have filed a review and you're not coming forward.
My lord, no, already we have the honorable court already directed us to deposit the amount, my lord. That we have.
Who is for the other side?
Other side is present, my lord.
Yes, madam, any objection? On the prayer for adjournment made on behalf of Mr. S. Chamaria, learned counsel for the review petitioner. This is the matter after 2 weeks.
My lord.
Yes,
Right, my lord.
Lordship, I beg to mention a WPC for listing, your lordship.
new case.
It's an old case, lordship.
Then you go to the registry.
We already filed on list on 21 of last month, but it has not been listed yet.
You go to the registry. Yes,
Today's list, item number 7.
yes.
Reading sir complete, my lord. I need to file an additional affidavit to bring out
Item 7.
7. Maybe taken up next week, my lord. I have received a communication from the bank, my lord. So I need to file an additional affidavit to bring.
You have to file additional affidavit. Mr. S. Sharma,
Action.
learned counsel for the petitioner. Prays for a week's time to file an additional affidavit. Praise the Lord. This is the matter after a week. Yes, madam.
Yes, your lordship, the order was passed is that that was an application which can be preferred before the respondent number 2, which was the relevant authority for such appeals. And the order was said, the order stated that if such an application is submitted by the petitioner, the same be considered in accordance with law and order, be passed within 4 weeks thereafter. So the petitioner has preferred an application, sent in representation to the to create relevant authority, but thereafter the respondent authorities have been did not reply to the.
No, what was the order passed in the contempt case that you filed in this court?
No, there was no order because
There was no order.
it was to be listed after a week, your lordship, but it has been more than a month. The petition
Okay.
the petitioner could not be
List
present.
them, okay, let it be on Friday.
Friday. Thank you. Obliged, your lordship.
May I please wait?
Make it Thursday. Yes,
May I please?
Please, my lord. My lord, we are seeking urgent listing of a matter on Friday for motion. My lord, matter pertains to appointment of an arbitrator. What had happened, my lord, despite the passing of.
okay, new case.
My lord, fresh case.
May I please?
Highly obliged.
With the concern of the other side, I beg to mention item number 16, your lordship.
Yes.
Matter may be taken after 2 weeks, your lordship.
Mr.
SK Sahab.
S.K. Sharaf,
Yes, your lordship.
learned counsel for the on behalf of Miss
And Avelia.
N. Havelia, learned counsel for the petitioner. Prays for adjournment. Who's for the other side? He submits that he has taken the consent of the other
Yes,
side.
Your Lordship.
Accordingly, list this matter after 3 weeks.
Oblige, your lordship.
Wait, please, your lordship. Lordship, pray for listing of some motion matters. My lord.
Motion.
Motion matter. my lord.
What
Fresh
is the
case.
matter about?
My lord, these are those matters your lordship has heard, my lord, these handloom matters. But my lord, the advocate general is appearing in this matter. My lord, in these cases, my lord, we have specifically pleaded and brought on record the Caesar part, my lord, wherein Caesar has taken place. So may I pray, my lord, may it be taken tomorrow.
What has happened to those other cases?
Well, those were listed last date on before Justice Devashish Dhruva.
Okay,
And thereafter, they sought time to file their affidavit. The affidavits were not filed. As per your lordship's order, they ought to have filed it on 4th or 5th of this.
Ha, ha, ha.
They didn't file it.
okay,
So the matter was, again, they sought for time, and they have, the last date was for filing for affidavit.
so similar orders have to be passed.
Yes, sir, that will, that.
Do it on Thursday,
Will.
day after tomorrow,
Tomorrow.
day after tomorrow.
Can it be tomorrow? I'll leave that.
May it please your lordship, I beg to mention for listing of matter for admission, lordship. In the earlier occasion, we have been instructed to file an affidavit in reply. They have already filed this affidavit, lordship.
So
So lordship, kindly list the matter next week, lordship, on 16th of May.
which item?
No, lordship, it's a-
You go to the registry, madam. Yes,
My lord, similar prayer for admission, my lord, next week.
go to the registry.
May please your lordship. Lordship, I beg to mention the blue PC for listing in order.
New,
Uh,
go to the registry, madam.
Please, Your Lordship, I beg to mention item number 25, my lord.
Yes,
The leading counsel, Indolent Stories, senior advocate is unwell, my lord. Let him list after 2 weeks.
okay, right. On the prayer for adjournment made on behalf of Mr. I. Chowdhury, senior counsel, who is apparently unwell. This is the matter after 2 weeks.
My lord, there is an interim that may be
Huh?
extended. There is an interim that may be extended.
Have you, do the others, this is the other side aware of it?
Yes, my lord. We informed
Okay,
us.
right, interim order passed, shall continue till the next week.
This petition is at the stay matter stage, this been
Huh?
settled, this writ petition I'm mentioning, 2022, it's been settled by compromise. Lordship can dispose it of in 5 minutes. Can it come up on Thursday or Friday?
Thursday,
My lord, regarding item number 19, I just come to know it was adjourned by mention, my lord. I have no knowledge about it. Just now I come to know, but I don't know what is the date fix, my lord.
oh, they said that they took I specifically asked them, did you take the consent of Mr. B.D. Das? They
But
said
I-
yes.
Maybe, but I'm the beneficiary. Response number 3, acknowledgement is given to me. That is the problem.
Oh, okay.
So that is why.
What have we said? Item 18, 19, I think is the first, what was the order?
On the prayer for adjournment made on behalf of Mr. G. N. Shaywala, I'm talking about the respondent number 4 to 7, on the ground that there has been been in the.
Ah. List the matter
This is the matter after a week.
after
A week.
a week.
A week, well, then always I understand, but. Always.
May I please your lordship, I beg to mention for listing of a motion matter tomorrow, madam.
Why, what is the matter about?
It's the eviction.
Eviction,
Eviction.
day after
For
tomorrow?
eviction, tomorrow is the date for eviction.
Okay,
But one motion matter, my lord, may I pray for listing on Friday, my lord,
what is the matter about?
regarding my lord demarcation of a particular plot of land.
Demarcation.
New matters.
Ah, demarcation. Okay.
Obliged.
Lordship, I have instruction to withdraw this petition with liberty, your lordship.
Mr.
M.H. Laskar.
M.H. Laskar, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. A. Chaliha appears for,
Respondent number 6, lordship, finance department.
respondent number 6, while Ms. S. Chutia appears for,
On behalf of P. Nair, my lord, PWD, my lord.
appears on behalf of Mr. P. Nayak, learned counsel for the PWD. On the prayer made by the counsel for the petitioner, the writ petition is dismissed, has withdrawn, come out with liberty as faithful.
I'm deputy.
Lordship, I'm for the petitioner.
You take this one. Yes, you are supposed to file affidavit in reply.
My friend, my lord, that's what I was just about to request. There was a delay on my part and I agreed for that. I wanted to file it yesterday, but my learned friends, he didn't accept it, which is okay. I have no problems on that.
Didn't accept it?
He didn't accept the affidavit yesterday. I wanted to file it yesterday. There was a delay on my part. I agreed on that delay.
My last order was my lord 14th March, my lord.
I agree.
For
I agree.
14th March, they took 2 weeks time, my lord. Thereafter, again, it was listed on 30th of March, my lord. Again, they took 2 weeks time, my lord. And my lord, 1 week before I told my lord, if it is not possible to accept my lord, 8 or 9, my lord, because I have to take instruction from the department, my lord. So my lord, yesterday evening, my afternoon, they served a copy, my lord. His
So only my lord, this whether this notice was served properly or not, that point is my lord required, my lord. With this, my lord, on one rail is my lord, there's art concert, art filling, my lord.
Huh?
So,
Art filling.
Art filling, my lord. It is my lord, I mean, Jogikapa, the other railway, my lord. My lord, but that was my lord cancelled, my lord. And there, it is order was.
No, what is to be done?
I'm only
My lord,
requesting,
there is urgency, my lord, this matter may be heard on 11, my lord. Because
You see,
my affidavit is ready.
there's urgency in a number of cases. The problem is the number of cases have been fixed for hearing.
it is this, my lord, stay vacation petition, my lord, this, I filed this.
They filed the stay vacation application, but that may not be very important because now the contract has already been given to somebody else. The contract which is in dispute now.
My lord,
The
there
only
is a-
problem is that I understand there is an urgency because the termination for me is also important because the termination according to me is completely arbitrary. That your lordships will have to decide. I'm saying affidavit is ready. If your lordships have got, if it is convenient for your lordships, Thursday also I'm ready with it. If
Well,
it is,
this is
if it is not
arbitration
inconvenient
point,
to your
my lord.
lordships, I
Arbitration
want
clause is
Tuesday, I
there,
have
my lord. Arbitration clause is when terminating, there is arbitration clause, my lord. If anything is that they may approach the arbiter because this is the public interest, my lord.
That has to be
It's
decided.
the railway, my
That
lord,
has to be
it's the way, my lord. It's the public.
Anyway, let him file the reply affidavit. In the meantime, you obtain your instruction.
11, my lord.
Hmm.
11, my lord, we'll try.
Next
have
week,
absolutely no problem.
next week,
Next week.
Next week, can it be on Thursday? Your lordship, it's not inconvenient.
Tuesday.
Or
You can
Tuesday.
do it Tuesday.
Tuesday is
We'll
okay.
we'll have to, of course, juggle with other petitions, other cases that are already there.
Because my lord, they are enjoying stay, my lord, from my lord, this order was.
No,
passed.
Mr. Counsel, I understand your problem, but
understand.
you have to understand our problem also. We cannot do all the cases that are in hand.
Yes, ma'am.
This delay, I admit, was on my part. The client was also traveling. I couldn't get the affidavit filed on the ramp. This I admit. But
14
otherwise,
March-
there's no delay.
14 March,
Everything
my
has
lord,
been
there's a
complete.
PM.
Meetings are complete otherwise.
2 months, almost 2 months, my lord, they have taken 2 weeks.
Anyway,
I
since
understand.
the contract has been given to somebody else.
No, yet not, my lord.
Huh?
Because of this order,
They
stay
floated
order,
the tender
we are
also.
not just only still.
They have floated the tender, put it on
That may be
affidavit.
clarified, man. That may be clarified, this railway authority may, there is already tender issued, my lord, that may be clarified. This one.
No, we'll see. Okay, then, you see, day after tomorrow.
Tuesday is
There are some cases fixed, I think. Huh?
Well, it is hardly, my lord, half an hour, my lord.
Mr. Counsel, half an hour maybe, but there are number of cases fixed.
Yes.
Whether we'll reach also, that's a different issue.
But due to this order, my lord, this contract, the only we issued the.
Mr. Counsel, there are so many cases you have got.
On 16, man, on 16.
Right. Mr. What?
RB Fukan.
Mr. R. B.
petitioner, in
Fukan,
both the
learned
matters.
counsel for the petitioner in WPC number 4811/2022 submits that he will be filing affidavit in reply today. And a copy after serving a copy. You serve him a copy now itself.
I serve on a copyright.
No, don't say anything. That's today. Full stop. Mr. S.K. Medi prays for urgent listing of the case as there's a stay order in favor of the petitioner. He also needs time to obtain instructions. Accordingly, leave this matter on 16th.
Yes,
Which is a fixed on 16. Grateful, extremely grateful for indulgence. There's some interim orders.
Interim order passed earlier shall continue till the next day.
Grateful.
My lord, from February, my lord, it was not continued, my lord. February,
But what was not continued?
interim order was not continued.
Not continued.
Not
Oh, don't continue.
Not
The
continued.
interim orders are there in both the
Not
matters.
continued, my lord.
Don't write anything over the interim order.
Yes, my lord.
No,
I leave it
that
to you. There's no vacating also, there's no application required. Grateful.
The Lordship will kindly take up item number 5 first. These are both same case. Item number 5.
Same case meaning?
Same means order is same, means connected with, my lord, a feasibility report in both the cases.
No, this petitioners,
Yes,
they are what? They
they
are
are the dealer under the Indian Oil Corporation,
both of them.
both of them.
So there is no clash between them.
No clash, no clash. So your lordship will, this is the second round of litigation. The first round of litigation, we came up before this court. Finally, kindly see the date.
Now, where is the first round of litigation? Where is
Yes.
the order?
Yes.
154.
Yes. 154 on 23-1. First, kindly see 154 interim order, 23-1/2019. My lord will kindly see what was our contention. Contention of petitioner is the respondent number 3 had issued notice for appointment of regular rural retail outlet dealership petrol pump in the state of Assam, including at Patila Daha Highway in the district of Bongaigaon at serial number 78 on Patila Doha Highway within 5 kilometers from so and so. Be it stated also had a retail outlet in the said location, but under the Indian Oil Corporation. Contention of the petitioner is respondent 3 has included the said location and notice for appointment of regular rural retail outlet dealership without carrying out the required exercise under clause 1 and 3 of the guideline for selection of dealers of regular and rural retail outlet. Having heard learned counsel parties and due consent till the returnable date, impugn notice for appointment of regular rural retail outlet dealership in respect of so and so in the district of Bongaigaon at serial number 78 shall not be given effect. So, my lord, if your lordship kindly see the notice at page 135 for appointment of this was put to challenge before this honorable court, and that was the order that was passed at 135. Kindly see on the top of 135. Notice for appointment of regular rural retail outlet dealership. This was issued by Bharat Petroleum Corporation Limited. Kindly see the second line.
Yes.
Proposes to appoint retail outlet dealers in Assam as per following details.
Proposes to appoint, yes.
I'm sorry.
Yes.
Now kindly see the petitioner before your lordship was agreed at page 138. These are various places which they have mentioned on from the top 1, 2, and 3. On 3, that is serial number 78. Serial number 78 on Patilaha Daha Highway within 5 kilometers from so and so. Area is Bongaigaon N, and the rural is rural outlet. There is also rural outlet. This is rural outlet.
There's urban outlet, rural
Yes,
outlet,
rural
is it?
outlet. So we are concerned about the rural outlet.
Okay,
So,
what is, first of
my
all,
lord,
what
the
is this?
subject matter?
What is this 1 and 3, clause 1 and 3 of the
Yes, I'll
guidelines?
just show you a lot. Let me come. Kindly see at page 148. This is what the challenge was, that they have not followed this 148. 6th of April 2011. This
Yes.
is, my lord, Chief Executive Officer of BPCL, SPSL, IOCL. Kindly the subject. New criteria for conducting of feasibility study for new RO preparation of new marketing plans. Pursuant to a meeting taken by the secretary on so and so on this subject mentioned, matter has been further examined in the ministry. It has been decided that while conducting feasibility study of opening of new RO, preparation of marketing plan future OMC, Oil Marketing Corporation, will henceforth comply with the following condition. 1. The OMC should consider the appropriate returns for financial viability of new RO, which form the gross margin available to
What is RO?
RO rural outlet.
Rural.
So which retail outlet, sorry, retail outlet, which form the gross margin available to Oil Marketing Corporation on so and so and so and so.
What is MS, HSD? What is
MS is, my lord.
It's a motor speed, my lord, and MS is motor speed, my lord, and it says even a high speed diesel, my lord.
Okay, this is
Petrol
one
and
is
diesel.
diesel, one is petrol.
Yes.
So, my lord, this is one which we said that it was not followed. Finance, that is, there is a financial viability, feasible viability has been followed by 3 oil marketing corporations. When this tender was floated, we came up before this court and we said, look here, 148 has not been followed. Now, on this ground, my lord,
148 clause 1 and 3 only.
1, 3, yes, 1 and
What
3.
does 3 say?
The oil market company works on a mechanism
where the ED retail of the three OMC may decide by considering the expansion of network in new areas, like developing suburbs in cities, new highways, road bypass, diversion or area like developing suburb in cities, new highways, road bypass, diversion or areas showing very high growth in existing infrastructure is inadequate. So we said, basically you have to follow this.
But to follow it, you see, how do you follow this? You have to follow it by working out a mechanism. Now,
Mechanism.
where is that mechanism?
Yes, I will show it. I'll show it, my lord. Now, when this, my lord, we moved, there was an interim order that, okay, there's now, my lord, in the course of hearing, an affidavit was filed by the Bharat Petroleum at 156, my lord. That is the litigation, 156. Now, 156. Feasibility conducted at page 162, my lord. The
Page 156.
156 is the affidavit.
156 is the writ petition, WPC.
Here, WPC, where the affidavit has been filed at page 157. 156 affidavit.
Affidavit of position.
Yes, this is by BPCL. Where, my lord, tender was floated. There stand at page 162, kindly see. 162. Second paragraph. It is further stated that notice for appointment of regular rural retail outlet dealership of the oil marketing companies is solely governed by voucher for selection of dealer for regular and rural retail outlet dated 24/11/2000 stated. 18. It is stated location have been identified as per guidelines enumerated in clause 1 of the PSC OMC manual for selection of regular rural outlet dated 24/11/2018. Pertinent location in rural areas have been decided through conscious of all PSC OMCs, namely BPCL, IOCL, and HPSL, to prevent same or similar location to be advertised by multiple OMC. In fact, now Lordship will kindly note down, feasibility study has been done for the location, which clearly shows that projected sale for the retail outlet as advertised by the deponent corporation meets the minimum commercial volume consideration. As such, assumption of the petitioner that no feasibility was done prior to setting of a new retail outlet that is not based on record. So, my lord, there stand before the court in
Who
the
stand? Who
litigation,
stand? Who stand?
the BPCL, who has Bharat Petroleum, my lord. Where, my lord, who has put in a tender? We said, my lord, feasibility has not done. Affidavit, they said feasibility has been done. Now, in this context, they have annexed a report before this court. That page 167. That feasibility report. Now, when this feasibility report was annexed, my lord, then we said, we took leave of the court that this is a new cause of action. If they are really, we are aggrieved. Court said, if you are really aggrieved, then challenge this because this is a new cause of action. So we took liberty of the court to challenge this, my lord, report at page 174. 174 and the operative portion 181, my lord. Dated 16/8/2022. Kindly see page 182. 16/8/2022 at 182. In that view of the matter and taking into submission the facts and circumstances, petitions stand dismissed on withdrawal, however, with the liberty to challenge the validity and correctness feasibility report, if so advised. Interim order past tense vacated. The court clarified disposal only basis of submission regarding availability of such feasibility report. Submission to allow withdrawal, and this court has not made any observation or interest in merit on the party. So, my lord, this was the order which was passed. In pursuance to this order, my lord, feasibility report has been put to challenge now before this court. Now, kindly see, my lord. Today, as on date, our stand is that there is no feasibility which has been taken because the Indian Oil Corporation itself, we have written a letter that please tell us, because oil marketing corporation has to sit together.
Oil India Limited,
Indian Oil Corporation, my lord.
Indian Oil,
Who I am a dealer,
IOC.
IOC. So my lord will kindly see that letter is at page 12, my lord.
No, just let me see this, 181.
181.
The dispute So in this, WPC 395,
Yes.
what did you challenge?
We challenge, my lord, the same.
Challenge
said-
what?
We challenge the tender on the ground.
You
that
challenge
how-
tender?
That's for notice, BPCL notice, my lord. At
Page,
page 135, notice for appointment at page 135. Notice for appointment of new petrol pump, my lord. So notice for appointment at page 135, you noted down 135. That is Bharat Petroleum Corporation Limited has issued a notice. And that your lordship, the petitioner is aggrieved at page 138, where your lordship has noted down. This is regarding this particular location, my lord, at page 138, serial number 3, my lord. Our
serial number 78.
Yes, 78. Our is that vicinity, my lord, on that area. So our whole grievance that how can you put one petrol pump without a feasibility report? You cannot put a propose a new.
Your petrol pump is Oil India Corporation,
Indian Oil Corporation.
Indian Oil Corporation.
Yes.
And his petrol pump is from the other
BPCL.
HPCL,
BPCL.
BPCL,
Bharat Petroleum Corporation Limited. BPCL.
So it's all based upon the letter dated 148, correct?
Yes,
Now, 148,
yes. All three,
is this an enforceable document?
yes, yes.
How do you say that?
No, they themselves, they stated, my lord, they themselves in their affidavit, they stated. If it was not enforceable, they would have said it is not enforceable. There is an affidavit which has been shown by
Okay, so according to you, there is no mechanism set up. There is no feasibility report.
No, there is a feasibility report which they have annexed,
Paid.
but they have not exercised. They have not exercised, my lord, so far feasibility of my petrol pump, Indian Oil Corporation. Three oil
So
corporations.
your petrol pump is an already existing petrol pump.
Existing long back, my lord.
And now, so page 167 is the feasibility report.
Yes,
So according to you, this feasibility report is not a feasibility report.
correct, my lord. And my lord, 173, can you see, it will appear. 173. There are 173, my lord. The feasibility starts from 167. 167, report.
Yes.
If your lordship kindly see 167, kindly see 167, feasibility document on the right hand, on the left hand side column. And kindly see location, dated 15/11/2018, location on.
Where are you? 173 I've got.
167, 167.
16.
It starts from 167.
That much I got. 167 is there.
Yes, kindly see feasibility document
Yes.
and kindly see location. Location on Patila Doha highway within 5 kilometers. And this is what my lord, your lordship seen that notice, which serial number 78. This is the location. And if your lordship kindly see, now you go on, my lord, now 168. there are two pumps, Oil Marketing Corporation, BPC, Bharat Petroleum, Saini, OMC, RO name, retail.
Where do you get that?
168 down below, column my lord, trading area average sales, your lordship got it,
Yes,
sale. Kindly see one, BPC,
yes.
this yours, so lordship will kindly OMC, Oil Marketing Corporation, retail outlet name, Saini. This is one of the name who is existing. And number two is Indian Oil Corporation, another pump, AIV. So my pump is not been taken into consideration. Number three, it should have been my pump which should have come because which is long back. Now, if you're
Yeah, the name of your pump is not reflected here.
now kindly see 173. 173.
What is the name of your pump?
My pump, Patila Daha Ananta KS, my lord, at page 183. My petrol pump. Now 173 kindly see my lord.
Yes,
This is kindly see serial number 1,
yes.
Saini service station. Number 2, AI Valley service station. Proposed plot P, nothing is there. So my pump has not been taken into consideration. To fortify this more, there is a letter which after the matter was over by this court, we wrote letter to Indian Oil Corporation. Please let us know whether feasibility has taken or not. If feasibility has taken, I have no case. I am out. Now that letter, lordship will find 183, my lord. We have written to the Indian Oil Corporation. At page 183.
Yes.
On 1/9/2022. Now, feasibility report. It is respond to case WPC. BPCL has submitted a feasibility report. The report is attached with the letter. In the report, it is stated that our RO, Ananta Kishan Seva Kendra, situated the same trading area, is not reflected. Hence, you are requested you to please check the report and give me the information given by BPCL is true or false. Now, kindly see, they have given a reply at 185. 185.
Yes.
2nd of September 2022, undersigned has gone to the feasibility report. It is seen location of AI Valley service station is incorrectly shown. First, since AI Valley service station is located on the left-hand side of so and so while traveling from Guwahati to Mumbai, that is also wrong. Also, location of Patila Doha Ananta KS, my lord, is not shown in this report, which is situated at distance of around 600 meters on the left-hand side, but while traveling from the point of NH 27 inserts. This is the execution.
So this letter is from whom?
This letter is being addressed to my lord, to us in pursuance to a letter which was written to them on 1/9/2020.
Written by whom?
By the down below, senior so and so Guwahati divisional office, retail outlet by Indian Oil Corporation, man.
Indian Oil Corporation.
Yes, IOC.
So not
Kindly
by
see
not
on
by
the-
HPC.
No, it's we are under IOC.
Correct.
So there has to be feasibility report.
So this page 67 is a feasibility report written by the Bharat Petroleum, is it?
This feasibility report, 3 oil marketing corporations to sit together and they have to find out. my lord,
So this 67
Yes,
has been made by only one,
yes,
is it?
yes.
Or by all three?
No, all one only, and they have not taken consideration of my pump. This is our case.
So
And
so they have not, first of all, they have not made this report along with the other two companies,
yes,
and also they have not considered your pump.
yes, that is they have violated. Now, that again will reflect to an Indian Oil Corporation itself, they have filed affidavit. Now, affidavit.
Who has
They have-
filed?
Indian Oil Corporation,
Uh-huh.
where they have to sit together. Now, Indian Oil Corporation is my pump, where is under dealership under them.
Is your parent pump?
Yes,
Hmm.
they said also, because 3 companies has to sit together.
Hmm.
My lord, absolutely, I will have no problem, my lord, if the feasibility report is there. And they will mention viability, and I will have no case, my lord. My case is that this feasibility will not work out. That is why I have come up before this court, and the court protected me. And my apprehension was correct. And when the report was filed also, that was also correct, my lord.
That's all.
Yes, and in the affidavit filed by the.
So your prayer is prayer for setting aside that feasibility report.
Feasibility, go a fresh feasibility.
And
report,
make a fresh,
fresh feasibility.
while
report and-
with considering your pump.
Yes, right, that's my prayer.
Yes,
And till then, they should not appoint any fresh appointment. And ultimately, feasibility take place, I have no objection, my lord, they should serve a copy.
yes,
If you go for a new feasibility study, my lord, he will be in a loser position, my lord.
he'll be in a,
He will be in a loser position, my lord, because.
let him be, he doesn't mind.
Now, my lord, kindly see, my lord, whether.
One second, before you start, there is one application has been filed, somebody I don't know,
He is
for
withdrawing.
impleadment.
Acha.
For impleadment, I don't know.
He will withdraw.
Oh, let him say that will withdraw, it will remain, then you are not sure, again there will be problem.
Yes, you want to withdraw? This is I number? 1010. This is by Mahanta Burman. Huh? 618322. Mahanta Burman. Is it?
Yes.
So you want to withdraw?
He, I think proposed plot is given to him.
Okay.
He came up before this court and he impleads a party, impleads himself and files an affidavit also in this case. And today, I think it is maybe, I don't know, he wants to withdraw it.
You have to withdraw.
Yes.
So, okay, he wants to withdraw. Mr. FJ, so Learned Counsel for the applicant in Learned Counsel for the applicant submits that on instructions from his client, Shri Mahanta Burman, he would like to withdraw the application for impleadment in WPC number 6183/2020. The pair of the petitions, and who appears for the other side? Mister? Anyone appearing for the other side?
I am for responding, my lord, petition.
Who is for the Union of India? Mister?
I am for the IOC.
You're for the IOC.
So accessory was a pain, madam.
Huh?
Accessory was a pain for series, madam.
Anyway, Mister
P. Bharadwaj.
P. Bhardwaj appears for the respondent number 4 and 5. Central government?
Accessory was a pain, madam.
And the prayer of the petitioners, the prayer of the applicant's counsel is allowed. The IA is disposed of, dismissed as withdrawn. You can go now, finish. Unless you want to carry on hearing.
Now, my lord, kindly see, madam, whether his legal right has been actually, my lord, infringed, my lord.
Whether his legal right has been infringed.
Yes, my lord. Because, my lord. Yes, my lord, it could not, my lord, show, my lord, that any legal right has been infringed, my lord, for setting up a new petrol pump within the vicinity of his case, petrol pump, my lord.
Have you taken that ground in your
Yes, my
affidavit?
lord. I have taken my para 8, my lord. Para 8 and 9, my lord, I have taken, my lord.
Yes, then number 2 point.
Now, my lord, kindly see page 33, my lord. His own agreement with IOCL, my lord,
You're for the
for BPCL, my lord.
BPCL.
For
Bharat,
respond- For Bharat Petroleum Corporation. Limited. Respond number 3, my lord.
yes. Page 33,
Yes, my lord.
yes,
This is the agreement, my lord, executed between the petitioner and the IOCL.
yes,
My lord, clause 4, my lord.
yes.
The corporation reserve the right without reference to or consent of the dealer to appoint one or more additional dealers in the same town, area or location. And such additional dealers shall be entitled to make sales of the product without any objection from the dealer, and a dealer shall not be entitled to make any claim for remuneration, commission or allowances whatsoever in respect of the sales made by the such additional dealers or sales made by the corporation through such additional dealers. Subpara is important. The dealer hereby expressly further agrees not to dispute, object, or to challenge the appointment of other dealers at the same place or at any other place, either by the corporation or by any other oil company or corporation for a time being corporation in India. But we have taken this plea in our affidavit, my lord, but there is no reply to that effect, my lord. Now he cannot, my lord, object, my lord. We will have doctrine of provisional establishment will also
Is
come.
the, okay.
In sugar mill,
Is the, now, so he cannot object,
yes, ma'am.
but the Oil India can object. IOC can object.
They are not objecting, my lord. They say that
They are not objecting.
no, madam. They are not objecting, madam. They said their petrol pump is standing in other side, madam. But does not, madam, visit anything, madam. I'll show, madam. And now, madam, if he were object, madam, it entails his termination also, madam.
Huh?
It entails the termination of his dealership also, madam. If he gets object the same, madam. In the agreement itself, madam.
The termination will be by the IOC.
Yes,
You,
madam.
you cannot do it.
Yes, sir. But the subpara is important, madam. They cannot object, madam.
Yes.
That's all. That's why, madam, the ISO did not object, madam.
That's all.
No, madam. Now, let's see as to how, my lord, so we have to cause, my lord, the feasibility study, my lord. As per the manual, I have even, my lord, one manual, my lord.
Yes.
Now, my lord, let me see, my lord, these are the, my lord, real retail outlet, my lord. Yeah, my lord, our, my lord, these are, my lord, these petrol pump are real, real retail outlet, my lord. In rural area, my lord,
Rural area outlet.
now here, my lord, our expected, my lord, combined sale volume is 25 kiloliter per month, my lord. If we find.
Where do you get that?
My lord, is page 1, my lord. In the manual, my lord. Identification of location, my lord.
Yes.
Clause, my lord, location for setting up retail outlet are identified by the respective oil company based on commercial / minimum volume consideration. Current volume norms are as under rural retail outlet E-class. Expected combined sale volume 25 kiloliter per month.
Expected combined sales volume. So expected of one petrol pump.
Yes, madam. Now we have to cause, my lord, feasibility study, my lord. If we found, my lord, there is a possibility of expected volume is above or 25 kiloliter per month, my lord. Then we are going to set up a new petrol pump, my lord. Now,
So it is expected that the petrol pump should at least have a sale of 25 kiloliters.
it's a minimum, my lord.
Minimum.
Now, my lord, what is the meaning of E-class, my lord? B, my lord. Roman 5, my lord, E-class, my lord. Retail outlet in rural area not covered under a municipal limit of a town under A, B, C, and D class of market. So what is, my lord? A, B, C class market, my lord, is defined, my lord.
Yes. Fair.
Next page, my lord, for feasibility, my lord. Feasibility of the identified location would be prepared annexure 1 and annexure 2 by the concerned divisional regional territory office. Identified locations should be specifically defined, clearly identify. Some of the example are so and so. Now, my lord, kindly see, my lord, two, my lord. Is there a retail marketing plan, my lord?
Just a minute. Yes,
But
D, no? Yes,
Now, my lord, the form of my lord, the model of my lord, the feasibility.
no, no, we've got D says retail outlets falling under E class of markets and having some.
It is on the dual area, my lord. Not in the highway, my lord.
So, E class, where is E class?
E class, my lord, clause B, my lord. Roman 5, my lord.
Hmm?
Clause B, Roman 5, page 3, my bottom page 3, my lord.
Clause B.
Clause B, my lord.
Rural area. Yes. B5.
B5, my lord.
No, you have to supply me a copy. I'm sorry, my, he has to supply me. a copy,
We have
my.
taken a plea, my lord.
If he relying in supply.
It's an internal document, my lord. We have taken a plea, my lord. They have not objected, my lord, in the reply, my lord.
What of, you have to, you are relying something, you have to supply me.
My lord,
my lord. That's,
First page,
I
my
think
lord,
that's.
I'll
you
see, my
can-
lord. There's a written, my lord. There's a restricted, my lord.
What to do?
Something is relying and not giving a copy, my lord.
No, but why you can, you
No,
have
I'll
to.
give a, I'll give a very good reply, very quick reply I'll give. He says that no legal right infringed.
Yes.
Today he is saying no legal in the second round of litigation. In the first round of litigation, he doesn't say about my legal right. Whether he is now stopped to argue.
No, how can you be stopped?
No, I think he has to be stopped in saying that I don't have a legal right.
No, how can it?
No,
If you don't have a if you don't have a legal right
What?
then, doesn't mean that you have a legal right now.
Now, let's say the subject matter being the same.
No, maybe.
No,
But
then
then- no, no.
2022, there is a judgment
Uh,
of a Supreme Court, my
uh,
lord.
uh.
If subject matter is the same parties,
Huh.
whether you can take a point of maintainability on the issue.
But then there are judgments of the Supreme Court which say that only a person whose enforceable right has been infringed,
Yes.
legally enforceable right has been infringed, can they file a writ petition?
Whether they have taken this on the first round of litigation.
Yes, my lord.
No. Let me
Once
say
it was
one
my
thing, my lord. Now my learned friend is now circumvent his affidavit because his affidavit is very clear, stating that there is a feasibility which has taken place. His affidavit is very clear. Today, he is saying something else, my lord. Now, as if the feasibility, he is trying to say something else.
I don't
Only-
know. I haven't fully heard him on that point.
No. That's why I'm giving a quick reply. Because his ground is no legal and infringement.
You see, his first ground is that there has been no, you don't have any legal right.
My lord, we have
Basically,
taken, my lord.
huh?
Page 161, my lord.
That is the first ground is taken.
No, that's why my reply on the first round. Let him complete, my lord. Only what I pray that he at least should have given the copy.
No,
to
you see, one thing is this. Now, I don't want to hear both of you. And at the end of the day, we adjourn it on the ground that this document is not there and he doesn't have it. So you take a call. Whether you want to have the hearing after having a copy
No,
of this.
of course, after he
No, I
he
can
realized
also
something I
my lord,
don't know.
Other documents, whatever is annexed with the petition, my lord.
Yeah.
Kindly see.
No. What about this document that you, he doesn't have, he says, he wants a copy.
Then he should not rely it, my lord. If he doesn't want, of course, fine, my
My lord,
lord.
we have taken this plea, my lord.
No, on what? No, I'm not on that, I'm not
Because
on.
It's a restricted, my lord. That's why, my lord, we have
Oh,
taken
This
this.
is restricted.
Yes, my lord.
This document is restricted.
Yes, my lord.
Oh.
That's why, my lord. In the top, my lord, it says, my lord.
It says restricted for internal use only. Okay.
That's why we have taken this plea also, my lord.
No, what we can do is, but then he's handicapped. We cannot have a conversation on the side.
Even if, my lord, if you know, if I not consider relying also, my lord. from the other document I can show, my lord.
So he'll be left out of the conversation.
From
So
the-
what we can do is, the relevant provisions of this manual which you are going to rely upon. You can maybe photocopy it, give it to him, and after the hearing, take it back.
But it is reflected in the affidavit also, my lord.
Okay, all this is reflected. Then don't go to this, go to the affidavit.
Yes, my lord.
Then don't rely upon this. Because
Now, my lord, kindly say, my lord, whether we have taken the plea, my lord, whether he has a locus standi or not, my lord.
whether he has,
Whether we have taken the stand, my lord, whether the petitioner has a locus standi to file this case, my lord.
no, not that. That is one aspect. One aspect, that is one aspect.
Yes, but if earlier round of litigation also, my lord,
You have
this plea,
taken
my lord.
that ground.
Para 10, my lord,
Page
161. My lord, senior counsel, my lord, has read, my lord, please sub para 10, my lord.
yes.
That with regard to the statement made in paragraph 9 and 10 of the petition, the deponent said the petitioner has no locus standi to selling the notice that so has no right of the petitioner has been infringed.
And what about in 395? In 395, did you submit any affidavit? Three nine five is at 174.
The order, my lord.
That is the order. Did you no, in this writ petition, this 174, you can see WPC number 395.
Yes, my lord. In
So
this
did
case,
you-
my lord, we have taken this plea, my lord.
You have taken this.
Yes,
plea.
madam.
In your affidavit.
Yes, my lord. Para 10, para 11, we have also taken, my lord. Para 17 also, my lord, we have taken, my lord.
This is 367, Mr. Count. There are, you see, prior to this, there were two writ petitions.
In the other writ petition, Pipasa Sulimanam, 6183, he has annexed this affidavit finding 395.
Okay, this is different. 395 is different.
There also the same paragraphs cover the locus.
395, 174 does not pertain to the petition. Pertains to somebody else.
Other case, my lord.
Huh?
There are two writ petitions before your lordship today.
I know, no. I'm talking about this content.
But if 177, my lord. This
Huh?
177 is a link case, my lord.
177, yes.
It's a link case, my lord, WPC 367. my lord.
Yes, Kavita, he's
Yes,
there. Yes. In three, oh, so it's a link case.
Yes, sir.
Okay, so that is there. Correct.
We know affidavit, my lord, page 189, my lord.
189.
Yes, my lord.
So I'm going to cut all this.
The same, my lord, same thing is.
I know, but then page 189
Yes, my lord, of our affidavit, my lord.
of your affidavit, 189. Yes,
Para 8, my lord.
yes. Para
8, my lord.
8.
Yes, my lord.
Yes.
That with regard to estimate made in paragraph 9 and 10 of the representation, the deponent is said the location for setting up the regular and retail outlet have been identified as per the guideline enumerated in PSU Oil Marketing Company Manual for selection of regular and real outlet dated so and so. Clause 1 of the guideline provides for procedure as to how the location are being identified, and for every reference same is accepted below. Identification of location. Location for setting up retail outlet are identified by the respective oil company based on commercial minimum volume consideration. Current volume norms as under A, B class cities expected combined sale volume 150 KL per month. National highway 150 KL per month. State highway 100 KL per month. Rural retail outlet E class expected combined sales volume 25 KL per month. And feasibility of the location would be carried out by the deponent corporation to examine the average sale of the trading area we should suggest to get the expected combination volume and estimated sale. Subsequently, upon approval of the feasibility study, location is being advertised. So far, guideline it is 6/4/2011 is concerned. The deponent stated Government of India, Ministry of Petroleum and Natural Gas requested the oil marketing companies to comply with the conditions enumerated in clause 1 to 3 at the time of conducting feasibility study, so that adequate financial return would be accrued from the new regular retail outlet proposed to be set up in the marketing area, except rural retail outlet. The deponent states that the three conditions as mentioned in clause 1 to 3 are not required to be complied with, as rural retail outlet are giving adequate financial return to the OMC. In the present case, location of so and so has been advertised by the corporation.
Where are you reading?
191 million.
Yes.
In the present case, the location of Patidoha Highway within 5 kilometers from NS 70 intersection has been advertised by the deponent corporation under E-class market, and the expected combined volume of the rural retail outlet is 25 KL per month. And in view of guideline, let us so and so feasibility study was done, which recommend to set up a new rural retail outlet in advertised location. Particularly, while conducting the feasibility study, the deponent corporation considered a nearby retail outlet of the advertised location to arrive at the sale potential. Considering only 2 retail outlets, one BPCL and one is IOCL, sale potential would come 63 KL per month, which is above the required projection to advertise under rural category. This is our extent, madam.
Can carry on reading. It is to be mentioned here
That the deponent corporation did not consider a petition retail outlet which was selling 100 KL per month. However, if the petition retail outlet would have been considered during feasibility analysis, the proposal for one more retail outlet apart from the one already advertised could be advertised in the space as per guideline dated so and so. That's why at the beginning, my lord, I have said, my lord, he will be in the loser position, my lord. We can, my lord, install one new petrol pump also, my lord. The average sale would be high, my lord.
This
Only my-
guideline 2411 is that page 148, is it?
Both also, my lord.
What is this guideline 2411?
The PSU marketing plan, my lord. In my lord,
Huh?
8, my lord, I have stated, my lord, page 189, my lord.
Page 189.
Yes, my lord. That one I have handed about the manual, my lord. PSU oil marketing company manual for selection of regular and retail out.
Okay, this one. But you have not annexed this.
We have taken a plea, my lord. 192, my lord. The deponent is not annexed the guideline that is so and so as it considered to be restricted for internal use only. And therefore it will be produced before this honorable court if the honorable court direct to do so.
What is so secretive about this document? What is top secret? What is it? Rocket science is involved or something?
He
Huh?
doesn't give to us, and my lord, he doesn't expect also. How if this is what you're relying on, at least he should give this copy.
My lord, kindly say
Internal,
page
how can
66,
he
my
do
lord, of the guideline, my lord, which is available to the candidate, my lord.
Page 66 of the writ petition.
Yes, my lord. Then my lord will turn to my lord, page 64, my lord.
No, you see, no, just tell me one thing. You have said that. Page 160.
67, my lord. 66, my lord.
56. Okay, 66 is the guideline.
Yes, my lord.
It is here.
Which one?
Page 66.
Clause 1, my lord, kindly.
No, this is different.
Yes, my lord. This is for
This is
internal use
different.
only, my lord.
Huh?
This is for internal use only, for the office purpose.
It's a brochure.
This is a browser for the candidate, my lord.
This is a brochure.
Yes, my lord.
Brochures.
The 64 is the brochure.
It is also
No,
reflected
what-
in my, it is also reflected, my lord.
Okay, where?
Clause 1, my lord, identification of location.
Clause 1, identification location. Yes.
Location for setting up retail outlet are identified by respective oil company based on commercial minimum volume consideration. That is what reproduced in the other my lord manual, my lord. Accordingly, regular rail outlet are set up by the oil company as under 2 rail retail outlets. Location of rail outlet but not in the highway and outside municipal limit town. And so far, my lord, the guideline, my lord, 148, my lord.
I think you've got to give a copy because you are reading from here, but you're not, they're left out of the conversation totally. They've
If
got
my
no
lord,
idea.
we can provide, my lord.
You provide. But you'll have to come up against his submission.
I have already, let him give it, but I have.
No, with regard to whether you have got the locus to file
I
this
have
case.
got a locus, I'll give a reply to it right now. Locus, so far as locus is concerned, my lord, I would have very well understood that if it was a third party, I don't have a locus. I am an IOC dealer. I am saying, questioning the feasibility report which they have furnished in the court. Vis-a-vis 148, that is a mandatory on their part that the feasibility of both the 3 oil corporate marketing companies sit together. And it is apparently they have not done it. Whether I don't have a legal right.
No,
Well,
I doubt. Then you make a complaint to the person to the authority who has said that they should sit together. Why should you come to this
So
court?
that's why I have written to when they.
So because there is, you see, it's not, it is just the order given. There's no statutory
This is a guideline.
My lord, otherwise,
repercussion.
no, what will happen? Each and every petrol pump will be.
We'll
there
do
without
that.
following.
We'll do that. Because now the only thing is that your basic grievance is with regard to the fact that you will not make enough money as you were making earlier.
No,
That is the
that's-
basic thing.
I don't want that they should not do business. I am a lawyer practicing.
No,
there
you see,
should be nobody else.
because at the end of the day, the main consideration for filing this case is that you'll be earning less.
No,
That's all.
No, that is
Not,
why.
that is not.
No,
it.
that's not, my lord, the question here, I don't mind, my lord. It's not that somebody, why right to business, everyone, let us understand my properly, I also am limited. Everyone has got right to do business. 19(1), my lord, it cannot be only meant for me, it's meant for the other side also. Now here, why the Oil Marketing Corporation issued, this Government of India issued that there has to be feasibility. Why? There is a reason behind, my lord.
I don't know. Then you make a complaint to the government.
No,
Let the
wait.
government take a
No,
decision.
but it's not that. On the face of it. No, my lord.
No, you see, what does the central
they have-
government?
They have said themselves.
No, because you see that according to you, it is the state government of India who has made this proposal that there should be a feasibility report.
Yes.
Now, if according to you, they have not made a feasibility report, then you go to the author of the document and tell him, look, your decision is not being complied with. Then we will tell the government, okay, take a decision.
The party, we made the party.
And what have they said?
No, that's why let's say they have not done anything. They have not.
No, but
filed.
what is the government affidavit saying?
Government, Indian Oil Corporation, kindly see.
No, not Indian Oil, not Indian Oil. Let us go
Union
to
of India.
page 148.
Union of India has not filed any affidavit in this action.
That is what I'm saying.
No, that's why I'm
Where
saying.
is the?
No, they have to come and say before this court, we made them a party.
Have you made a complaint to this authority, to the government of India, Ministry of Petroleum and Natural Gas, that you have issued this letter of 6th April 2001, directing all the OMCs to make a mechanism or a feasibility report with regard to the setting up of a new petroleum pump.
What I'm on, that feasibility report has been submitted before the court.
Maybe,
That's why.
maybe, but that just because all cases that come here doesn't mean that they have got merit.
No, feasibility.
I'm not talking about this case, but
No,
I'm
what
saying
I'm
that
saying-
all writ petitions
No,
that
no.
come to this court.
Feasibility report
doesn't-
has been furnished before this court. And
Maybe,
they said, no,
maybe.
they said that they have done it. This is a false statement they have made.
No, that is a different issue. False statement or not.
No,
That is
no,
not
my
it.
lord.
My
With great respect,
question is
I'm
different.
saying. With great respect, I'm saying that 140, the statement which they have made, there is a feasibility, we said this is a false statement. On apparently IOC has said that yes, where is that feasibility has taken place?
Well, you see, according to them, it is a feasibility report. Rightly or wrongly, this court might say, yes, it's not a feasibility report. But the question that he is now raised is, what right of yours has been violated? You are
Right.
still allowed to do your business. Only thing that is going, you are going to suffer, maybe, is because if a new petrol pump comes, your business will go down a little bit. Your earnings will go down a little bit. Besides that, no fundamental or legal right of yours has violated. That is what he's saying.
You know, that I humbly differ with the argument that has been made by. my
Well, that is
friend.
what he's saying. You
No,
can
no,
differ.
that's
So
what I'm
you,
saying.
so
I
you,
differ.
you address that issue.
No, I address, that's why I'm addressing, my lord.
Yeah.
My legal right is he can't say that I don't have a legal right to come up before this court. Your lordship can nullify my right. That's a different.
No,
case
I
of the
cannot
argument.
nullify your right.
No,
I can just see.
nullify my argument,
Yes,
nullify my argument to the extent that you don't have a legal right. You don't have a legal right because you have come only for the purpose. It will not infringe because the person where they are going to establish a pump, somebody will come, your business will go down. That's what my lord. But why am I questioning now also myself and putting a question that this particular document has been 148 by the government of India? There's a meaning to it, my lord. There is a meaning to it. What I am saying, my lord, there is a meaning to it. Well, London friend shouldn't get up. You said yes. I thought that. So there is a meaning to it at page 148, my lord. What I am saying that why the purpose? For what purpose they have given this? Today, you cannot argue because once I challenge that, your report, you are now saying totally a reverse judge, something else. You are not relying on your own statement which you made on affidavit. On affidavit you made, you are not relying. You are giving a reply to my writ petition which was filed earlier. That time you did not raise. You may have.
No, he raised.
No, but
Para 10 and 11.
my lord, he could have raised that point that you don't have a legal right. He participated through a whole proceeding.
No, he said it. He said it.
No, but that is court has not given to any finding.
Because you withdrew the case.
No, I withdrew case on the different ground.
Whatever it is, the
No,
court
I-
did not dispose of the early writ petition on merit. It
But-
was disposed of by way of withdrawal.
But my lord, maybe
That
on
does not
withdrawal-
bar him from raising it
No,
again.
I'm not saying, my lord, that bar doesn't bar raising this point, my lord. I'm not saying that. My lord, if my legal right is totally, it will get infringed. He's saying that there is no infringement of your legal right. What fundamental right you have got to come up before this court to ventilate your grievance, my lord? I have got a petrol pump, Indian Oil Corporation, a petrol pump existing, my lord. There itself. You want to set up very well, you can set up. Absolutely. I told my lord on the very beginning that I have no problem in setting up. I cannot restrict someone that I have pump, I should only earn. Then, my lord, what is the answer to 148 today? Why he is going something, making a different argument, saying what he's saying on one. Let's see there his affidavit. Kindly see his affidavit, my lord, for a moment. In the round of litigation, which in earlier round of litigation, kindly his stand, my lord, at 162, my lord. 162, kindly stand. He's turning a U-turn, my lord, 162, my lord.
Yes.
It is further, second, 162 by BPCL.
Yes.
162. It is further stated, notice for appointment of regular rural retail outlet dealership of the oil marketing company is solely governed by the brochure for selection of dealers for regular and rural retail outlet dated 24/11/2018. It is stated, location has been identified as per the guidelines enumerated in clause 1 of the PSU OMC manual for selection of regular and rural outlet dated 24/11/2018. Pertinently, location in rural areas have been decided through conscious of all PSU, kindly note down, OMC's manual, BPCL, IOCL and HPCL to prevent same or similar location to be advertised by the multiple OMC. In fact, feasibility study has been done for the location, which clearly shows that projected sale for the retail outlets and advertised by deponent corporation meets the minimum commercial volume consideration. As such, assumption of petitioner that no feasibility was done prior to setting up a new outlet is not based on record. It is contrary, he's saying something blatant lie, my lord. How, my lord will kindly see.
Now you come
conscious.
to para, para 11,
Para
11.
11. That with regard to statement made in so a deponent say petitioner no locus can challenge the installation of new retail outlet in the advertised location because no legal petitioner has been infringed. It is stated under 19(1)(g) of the Constitution, all the citizens shall have the right to practice in any profession or to carry on any occupation, trade or business. Same could not be could be challenged or it could not be challenged. In the present
Yes,
case,
Mr. Roy, you are here. You are the CGC. Yeah, we need you.
BPCL. The BPCL na Union of India. He is Union of BPCL. She appeared for BPCL. Na? How can he take account?
Acha, he's for the BPCL.
He appeared once. My
For the
lord. Today he is
BPCL.
for Union of India. Let someone come from Union of India.
Are you for the BPCL?
You appeared. Then how
Huh?
can he?
It was filed by. It was filed by.
For the BPCL? Then you cannot appear as CGC. Then you cannot appear, you cannot, I mean, it won't be fair.
That's why one should. No, my lord.
No, anyway, if you have appeared for the BPCL, then I don't know. Okay, but you tell me, if you are appearing for as CGC, what about this letter at page 148?
Can I clarify?
Just a minute. You'll get, I'll give you all the time. We'll dispose of this matter. Now, you see, the petitioner has a problem. He says that this letter, the directions passed in this letter has not been complied with. So what has the government, what is the government stand on this issue? Is this a enforceable direction?
This is the guidelines, Lordship.
Is it enforceable? There's a guideline.
Guideline.
So it's not enforceable. No.
My lord, only one thing, if it is a guidelines, so your lordship will kindly note down, it will be not relied at any point of time anywhere now.
No.
No, if it is not that they.
No, you see, guidelines can be relied
No,
on
that's why
sometimes.
one case.
But
they have-
you see, you cannot enforce it in a court of law,
No,
that's all.
why, let them, because my learned friend BPCL today is from Union of India saying that it is not amended. Well, let it be a fair one, my lord, let it say, someone come up
No,
and say.
you see the transfer policy or the transfer guideline made by the government of Assam. Sometimes it is applied, sometimes it is not applied. Doesn't, the only thing is that it's not strictly enforceable in a court of law. That's all, but it's a guideline, not nonetheless. Okay, that's all I wanted. So government of India has not filed any affidavit. Is there some other CGC? who can appear? You can call. Yes, Mr.
But page 148, my lord, kindly see,
Huh?
but this is the government of India, my lord. Emphasis on, my lord, what would be the net profit put by the oil company, my lord, with regard to whether it should be A side or B side, my lord. In C side area, my lord, in location, my lord, the dealer, but the licensee, the license holder has to develop the petrol pump, my lord. In A side, my lord, the
Where is that?
it is here, my lord.
Don't go to the manual.
67, my lord. 67, my lord.
Page 67.
Yes, my lord.
Yes,
Type of retail outlet site, my lord.
yes.
The type of site will be decided by the oil companies and the same would be one, location under corpus fund scheme CFS. The offered land would be taken on lease, purchase and fully developed as corporation owned site. Two, other corporation owned site CC / A site. The offered land would be taken on lease, purchase and fully developed as corporation owned site. Dealer owned site DC / B site. The offered land and the superstructure will be developed by the dealer.
So what does this got to do with this case?
Here, my lord, kindly see B 148, my lord. Their emphasis on my lord B side, my lord, because my lord,
Page 48, 148.
yes, my lord. Pursuant to the meeting taken by Secretary so and so on the subject mentioned above, the matter has been further examined in the ministry. It has been decided that while conducting feasibility study for opening of new retail outlet, preparation of marketing plan in future, OMC will henceforth comply with the following condition. The OMC should consider the appropriate return of the financial viability of the new retail outlet, which is from gross margin available to oil marketing companies on motor speed, high speed diesel is rupees so and so. The OMC should give greater emphasis on setting up B side retail outlets in preference to A side retail outlet, as the cost which would be much lower, while return would be similar. OMC will have to work out a compensation mechanism for B side retail outlet where dealer is compensated adequately. OMC may work out a mechanism where the executive director retail of the three OMCs may decide by the consensus of the expansion of network in new areas like developing subsurban in city, new highway, road bypass diversion, or area like developing subsurban cities, new highways, road bypass diversion, or area giving showing very high growth and existing infrastructure is adequate. This should be inadequate, madam. No, next page, but no restriction may apply for real retail outlets which are anyway low cost retail outlet are giving adequate returns. He's talking about only the net profit which should be earned by the oil companies, my lord. So they are emphasis on B side, my lord.
You are a B side.
Yes, it is a B side, madam.
No restriction may apply for rural ROs.
Because the dealer has to invest all the money, my lord.
Ah.
In A side area, the corporation will have to invest the money, my lord.
So
That's
no
why they are preparing
restriction
for
may
B side,
apply. So no restriction should apply as per this letter
Because
to retail outlet.
Several factors are involved because the market price of the land also lesser than the A side area, my lord.
In any event, as per this 148, you were supposed to make a OMC with the, I mean, you were supposed to make a plan with
Yes,
the
ma'am.
other OMCs,
Yes, my lord. But
not done.
it is done, my lord. Feasibility study was done, my lord,
By who?
by the BPCL, my lord.
Only, no, with the others also, it has to be done.
But after carry out the feasibility study, my lord, they place the my lord.
Okay. So it
Feasibility
can be done by one person only.
Yes, my lord. That's why the advertisement issued by all the three companies, my lord. BPCL, SPCL, and IOCL, my lord. I'll see the advertisement, my lord.
Now, for page 149,
Yes,
it says that no restriction may apply for rural ROs.
because basically, my lord, the really, my lord, the.
So does it mean that this letter dated 6 April 2011 will not apply or what? What does it mean?
In rural area, my lord, it is not applying. my
And
lord.
this petrol pump that you're going to set up is in the rural area.
Yes, my lord. If we develop, my lord, it being a my lord, air side, my lord, because there, my lord, the market value of the land also my lord, lesser than the my lord, air side area, my lord.
Now what else? So according to you, now what the petitioner is saying,
Now, my lord, after my lord, carrying out the feasibility study, my lord, entire my lord, three companies came together, my lord. and the feasibility study my lord, placed in the in a present meeting my lord. Then they will decide my lord, where to they have to going for setting up a new petrol pump my lord.
So after this feasibility
Yes,
report at page 167,
Yes, my
the
lord.
three companies will sit together
my lord.
and
That's-
decide.
That's why my lord,
So that has not been done till
it
date.
was done my lord.
That was done.
Done my
Where?
lord. That's why my lord, the advertisement issued by all the three companies my lord, together my lord.
Acha, the advertisement issued by three
Three
companies.
companies my lord.
Where?
Now kindly see my lord.
In the other writ petition or what?
I'll show my. Huh? One. ಇದು ಮಾಡ್ಬಿಟ್ಟಿಲ್ಲ ಮಸ್ತ್. But the advertisement issued by the Bharat Petroleum here, madam. But this was issued by the Bharat Petroleum, madam.
That's what, not by all.
But my knowledge, madam, whatever I gathered, madam, it has, they have to sit together, madam. They after they have decided, madam. Because my kindly see, madam, in the
You have to go by, when you say something, it'll have to be supported by
because my kindly see, madam, in
documents.
the area, madam, IOCL or HPCL is not going to set up new petrol pump, madam. Only BPCL is going to set up a new petrol pump, madam.
So, but then you have got to think of the consequences of setting up a petrol pump. Whether the new petrol pump is going to earn enough
Yes, my lord.
compared to vis-a-vis, no, compared to vis-a-vis the other petrol pumps also, and compare, keeping in mind the other petrol pump.
Yes, my lord.
Now, in this feasibility report at page 167, the petitioner's petrol pump is not reflected.
First of all, they cannot compel us as to how, my lord, we should go for a feasibility study, my lord.
Okay.
Because these are the expert person, my lord. They know, my lord, very well, my lord, as to how, my lord, it has to be carried out, my lord.
Is it?
Yes, my lord. That is the, my lord.
But then isn't it logical? Supposing I'm going to set up a restaurant. Supposing I'm going to set up a restaurant in a busy marketplace. Won't I take into consideration the other restaurants that are going to be that are already in existence near the place where I'm going to set up a new restaurant?
Because my kindly see, my lord,
If there is one pani puri wala here, or 10 of them, and if I'm going to sit right in the middle of them with a new pani puri basket, won't I consider that will my profit will be enough or not? And won't I consider all of them, or I'll consider only one or two of them?
but there is no prohibition to set up a new.
No, I'm not saying there's a prohibition. I'm not saying that. I'm not saying that. I'm just saying logically, you would consider the earnings of everyone.
That's why we have stated, my lord, in the affidavit, my lord, if you taken his case of petrol pump, my lord, one new petrol, we are going to set up a new petrol pump also, my lord. Now, so far, my lord, locus standi is concerned, I am relying on person, my lord.
Here, basic case is locus standi.
Yes, madam. And because they cannot compel us as to how it should be done, my lord. And page 33, my lord, they
You are the respondent number?
3, my lord. And page 33, my lord, in their own, my lord, agreement, my lord, they cannot object, my lord, for setting up a new petrol pump by the other companies also, my lord.
Okay. What is this? Noor Khan, Patan and all that?
Yes, madam. I have one copy, madam.
Huh?
Yes, madam.
Noor
Page
Khan.
madam 9, 10, madam. 9 to 17, madam. Ayub Khan, Noor Khan, Patan, madam.
You have not given me that. You've given me this, what is this? Ganesh Chandra Hazarika.
Glucose of grammar school, madam, these are PB council judgment was discussed, madam. Sanam,
No, which one? Tell me which case are you relying upon?
madam, this, madam, Ganesh Chandra Hazarika, madam, can you see first of all?
Yes, which para?
Para 9, madam.
Yes, what does it say?
Here, madam, the two petition has been formulated, madam. The two basic questions are involved in this petition, whether the petitioner being honored by petrol pump has the right to object to the setting of another petrol pump by respondent number 6 within the same business area so as to impair turnover and thereby his fundamental right to business. Now, madam, from para 11, my lord, the maximum was discussed, my lord.
9, 10, 11.
Yes, my lord.
What else? Give me all the paragraphs. Don't give me one.
11, 12, my lord, 13, 14, 15 and 16, my lord. He says, if there is a malified, my lord, if I going to prevent him, my lord, we never prevent him to do their business, my lord, also. Next, my lord. Next, my lord, 1976, 1 SCC, 671, my lord.
1976, 1 SCC,
671, my lord.
671 para.
My lord, para 37, 38.
37, 38.
And my lord, para 47, my lord. And 48, my lord. Hospital.
And
I'm related one month, High Court of Telangana, the Gulu Raja Reddy, madam.
Telangana, you have given me Madhya Pradesh. Gwalior bench. Yes.
One more is
Which para?
on who's madam?
This Bolu Raja Reddy,
Please, para 17 and 19.
17 and 19.
Yes, sir. Yes, about the policy was not silenced, my lord.
Policy was not challenged?
Both are, my lord.
Huh?
The both are, my lord. Yeah, but the minimum, my lord, combined volume, my lord. Clause 1, my lord. In case 86, my lord. As to how, my lord, is to be considered, my lord. And my in Madhya Pradesh, my lord, the Munnalal Agarwal, my lord.
Yes.
Yeah, my lord, para 6, my lord. 6, 7, 8, 9, my lord. He says about the policy reason, until unless there is a malified bench, madam, it cannot be sentence, madam.
That's all.
No, no. Whether court can go into that as an expert mechanism set up by the expert, the feasibility study was done by some expert of the corporation. Whether court can go into that aspect.
Tender aspect.
Yes, madam.
He's not on that.
Because they have said that it was not taken into consideration, madam. Why it
His
was not into
basically,
consideration, madam?
his basic case is that 148 has not been followed. And in the feasibility report, in as much as the petitioner's petrol pump is not included in that feasibility, that's all it says.
In a selfie construction, madam. In
Shilpi construction is. What?
But it says that, madam, until unless there is a malifiedness, madam, regarding madam, because the decision making process, madam, because the petitioner cannot challenge that decision, madam. And the Bharat cooking, madam.
Citation. Why are you giving me so much more?
As the senior counsel is sitting against me, madam. We have to prepare more, my lord.
I will prepare more, correct.
Yeah, my lord. In Silpi Kasasam, my lord, para 7, my lord.
Yes. 7, 16,
Yes, my lord.
17, 18, all that.
And 19, my lord.
20 also.
Yes, my lord. In Bharat cooking, my lord, para, my lord.
Huh?
In Bharat cooking, my lord, para 31 to 34, my lord.
In which? Ayub Khan.
Yes, madam. In Bharat cook, my lord.
Huh? In which one?
Bharat cooking, my lord.
Okay, Bharat cooking coal.
Yes, madam. Para 31 to 34, my lord.
Para 31 to 34.
34.
Yes.
And my lord, promissory estoppel, my lord. Yes, regarding promissory estoppel, madam.
Huh?
Promissory estoppel, madam. Regarding, madam. Because they cannot object, madam, now, madam.
Where does the question of promissory estoppel come into
They have
play?
promised, madam, to the IOCL that they cannot object, madam.
No. The promissory estoppel is when you do something on the basis of a promise given by them and you have changed your position.
Now they have changed, my lord. They have objected, my lord.
Mr. Counsel, you are,
I may be wrong.
this is not applicable.
That's all.
Where is the question of promissory estoppel here? How have you changed your position? What position has you changed? What loss has been caused to you? Nothing.
Because the agreement.
It is
binds
like
them,
this, supposing I give you a supply order. You make the supply. You have changed your position because you have spent money and given the supply. And I don't give you the consideration. That's called promissory estoppel. That's in simple terms.
But the agreement binds them, madam.
Huh?
The agreement binds them, madam. Not to
Agreement binds them with IOC.
No, madam.
Oh,
It's Sapeda also, madam.
Okay. But that is with the
They
YC.
cannot object, madam, for setting up unit by the other dealers also, madam.
If the parent company doesn't object.
Yes, madam. They have not objected, madam.
And where is the promissory estoppel? What loss is caused to you? And where is the promise given by him to you? In promissory estoppel, there has to be a promise given to you by someone. Who has given you the promise? 1 minute. Wait, one- Who is for the Oil India?
Indian also, Steve Hurd does, my lord.
Huh? Who?
Steve Hurd does, my lord.
Was he here?
Yes.
Yes, Mr. Mr. Didas, anything?
I think Oil India, Indian Oil Corporation, I don't know what they will say. But only the point of the judgment which my learned friend has shown, some few such judgments of this court, of the Supreme Court, Silpi construction, these are all, my lord, we go through.
Yes,
all
those
those
are
judgments.
normal.
That's why I said, when you have some case, you have to, don't say too much because at one point of time, it may go against you. So by legal right, your lordship is questioning on legal right. Absolutely, your lordship is right. At a point, at earlier point, I may not. By once you consider, you have considered the feasibility report, then against me. Feasibility is against me. Lordship will kindly say they have done feasibility. This time it has been conducted. Conducted in respect of mine also they have conducted. So whether that feasibility report I am agreed because you have taken a decision. So my legal right stands. My legal right stand to challenge the feasibility report which has been furnished before the court. That is why the liberty was given by the court that yes, this is a new cause of action, you can go ahead. It's a separate, your lordship may decide whether my legal right flows now much, my lord, because of the report.
Where is your representation to the authorities that this has not been done?
We have not given that. Let me very point blank, we have not given. One answer, not given. Not given.
So,
We,
now.
why not, sir, let me be very honest. When the matter came up before the court, there was an apprehension. Well, we put straightforward. When they have issued this notice 138 at page 138 for appointment of this petrol pump by BPCL, then my apprehension is that when the 2011 notification on the Government of India that feasibility has to be conducted, we said that there is no feasibility has taken place. I didn't knew at that relevant time. I felt that why this petrol pump here? Everyone had got right to do business. Then the court said yes, file an affidavit showing whether there is a feasibility has taken place or not. When they came up with an affidavit in that round of litigation, they said the feasibility has taken place in respect of our petrol pump. Then I can raise grievances in that court because the cause of action is different. I told very frankly the court I want to withdraw it. With a liberty to file and challenge it, call my client, call a letter to the IOC whether you have also taken into consideration or not. All this exercise was done, my lord, calling the client, writing a letter to IOC. And they said that no, we have not been taken into consideration. That's what they have said in the report. So this was put to challenge. After hearing it, some interim order was being granted by this court. Now today, what is my friend is retracted. Our earlier step is challenging my locus, my legal right. Now, one of the judgment I just noted down. Judgment is said that prevented. We have never prevented. He said about malafide. You have prevented, no doubt. You have prevented me for carrying on a business. That's not prevention. My prevented only your lordship said about the viability. What viability, what feasibility you have taken place? You have done it. I am aggrieved by the decision of yours. This is why I have put to challenge. Aggrieved by the decision which ex parte you have taken. Lordship was asked. They said, no, we have taken the decision. But that decision, feasibility cannot be taken singly, my lord. When feasibility takes place, my lord, the guideline says all the three companies have to sit together and they have to take a decision that whether feasibility is there or not to set up a new petrol pump by any of this oil marketing corporation. That's what feasibility. Feasibility cannot be an ex parte. That's my humble submission before your lordship. I don't have any, I cannot point out if feasibility has taken place. I don't have any case at all. If feasibility has taken place, my lord, I don't have, your feasibility is ex parte. Your lordship has asked that question. I know that said, no, we have taken. We can take it. No, you can't take a decision ex parte. I am aggrieved. Why? I have shown by without consideration my pump. That is why I am aggrieved. Whether I will not have any legal right to come up and say before this court, I am aggrieved by our decision. My lordship has asked that if that is not done, why didn't you complain before the government of India? 148.
You see, one thing is whether you have an enforceable right. That is my issue. That is the issue, whether you have any enforceable right which has been violated by them, whether it is enforceable. And if it has been violated, what is the penalty that can be imposed? What is the repercussion of that?
What will happen? What is my enforceable right? My enforceable right would not have been there, would have been there if no decision was taken by them. They have taken a decision, logical conclusion. They have said that we have done it. I am aggrieved by the decision. I have an enforceable right to challenge it before the court. This is my humble submission before your lordship.
But one thing, now your enforceable right according to you is in terms of page 148.
Yes. And in not only 148, in terms of 148, where they have taken a decision ex parte
Now,
regarding feasibility.
if your enforceable right flows from 148, that is from the government of India letter.
Yes.
Why haven't you complained to the authority?
No, I'm telling you, I'll give an answer to it, my lord. If this feasibility report would not have been furnished before the court, that feasibility report is there, and apparently I have shown they have not taken any, consider my pump. So can I not complain? Because that is I have got some right to come up before this court. Why, my lord, with great respect, will go before an authority, the government of India, to complain that this is, look here, this feasibility. I have got
No, because they issued the letter. That's
no,
why.
that's right. I accept it. They issued the letter.
It is not an act. It is not
They
a.
have issued the letter. Absolutely, they have issued this letter of OM. But in compliance to that letter, the BPCL has taken a feasibility, has done a feasibility. I'm agree by that, my lord. But today also, suppose they do a groundwork feasibility of all three companies and they furnish a report with this court. I don't have any case. I'll say that, no, sorry, I don't have a case, I'm withdrawing it. Because this is a feasibility which they have taken.
Anyway, I think
And secondly, clause 4.
Yes.
Clause 4 is not binding. Clause 4 is between the Indian Oil Corporation between us. Not before, because it's a contract between the first party and the second party. A third party does not have a right.
So your petrol pump is in a rural area.
Yes. Rural
So the petrol pump that they're going to set up is in a rural area.
Yes, same.
So with clause 4, does clause 4 mean that this page 148 would not apply?
Well, no, my lord.
Does
With
it mean that?
respect,
What is the meaning of this?
No, that is, no restriction may apply. We have to read. We have to read from paragraph 1.
Yeah.
For 148(1). It is only OMCs should consider the appropriate return for financial viability of new RO which from the gross margin available to so and so. Number 3, OMC. Now number 2, OMCs may give greater emphasis setting up of B site RO in preference AO site, as the cost would be much lower while
So
returns would be similar.
B site and A site is not rural. Rural is different.
B side, rural, my kindly, we'll just show to the brochure at page 68, I think, Mr. My learned friend has just pointed out, which I remember the page 67. B is my learned friend B is 67, Roman 2, dealer own site DC B sites. Lordship kindly 67.
Yes.
3, type of retail outlet site. 1, 2, 3. Dealer own site, the offered land and a superstructure will be developed by dealer pump tank automation signature will be provided by the corporation. So all has to be on the borne by the dealer, developed by the dealer. In some of the petrol pump, my lord,
So actually, the development cost should be borne by the dealer. That's what they want.
yes,
Now, but then three, it says OMC may work out a mechanism
yes.
where the ED of the three OMCs may decide what consistent exemption or when it was
Road bypass, Everson, so and so, very high good
no
existing.
restriction may apply for the. So no restriction can apply
Yes.
for rural RO.
Which are anywhere low cost ROs and are giving adequate returns. These are pumps Miller, which doesn't give an adequate return in rural area. That is 148 has to be looked into it. My lord sir may not exclude only 4, read with 1, 2, 3. 3 is oil market may work out a mechanism.
No,
where the-
and supposing they don't work out a mechanism for 100 years, then what happens?
No, now my lord,
Because they have got to work out a mechanism.
this is a mechanism they have worked out. And that is the report which has been furnished before the court. That
No,
report-
that is a mechanism
Yes.
not made by the three OMCs. It
No,
is
that-
made by only one.
No, that is, my lord, that is the wrong which they have done it.
Now, that is the wrong,
Yeah,
but what
that
I'm
is
saying is, when there is no mechanism as on date, then what happens?
I'm sorry,
Can-
my lord.
As on date, when
As
there
on
is,
date-
there is no mechanism made by all the three
No, no,
companies
there is a
together.
mechanism which makes, your lordship will kindly ask Indian Oil Corporation also whether they, because these are what we have been done. Feasibly, no.
Okay, let me ask them. I think
Why not?
we're going same back to say
Yes.
square one. Yes, is there any mechanism? We have taken enough time, I think, too much time.
So the feasibility report, my lord, the three oil marketing companies do sit together, my lord.
The three?
My lord, and it is not only the three oil marketing companies, my lord, it concerns other oil marketing companies also.
Or
All of them-
other,
oil marketing companies are also there, my lord.
Yes.
All of them sits together and
you are set together.
yes, my lord.
And thereafter,
And a roster point is followed.
okay.
The BPCL,
And thereafter, you all made you all issued the tender.
yes, my lord.
Tender was issued by the HPCL.
My lord, individual NITs might be issued by the HPCL or BPCL or IOCL. But my lord, the locations, they are in the roster is followed, my lord.
Okay, now another thing is that I think from now on I'll have to cut down your timings. Too much time. Now, one thing is that now in this case, petitioners council submits that the name of the petitioner's petrol pump is not reflected.
Yes, we admit, my lord. It was.
So what does that mean? That means it was not considered.
It was not considered. My lord, we have stated so in our affidavit.
Then if it is not considered, thereafter you still looked into the feasibility report made by the HPCL,
My lord.
correct?
BPCL, yes,
Huh?
yes.
And you all have agreed to it,
My lord.
isn't it? That is the only, what have you said in your affidavit?
Well,
That
we have-
you have agreed to the advertisement being issued after seeing the feasibility report. Is that correct?
Well-
So you all have not objected to it.
No.
Is that correct?
My lord, that is what is in my affidavit. My lord.
That's
I
in your
cannot- I
affidavit.
cannot submit beyond my affidavit.
So I think, so in that case, if you have not objected to it, then the petitioner, can he object to it in terms of your agreement?
I can't object, my lord. Let us be very honest. If Indian corporation today is saying before the court that feasibility on one hand, he is saying it has not been done.
Yes,
On other hand, saying that it has been, we agree.
we
then I
agree.
have nothing to say.
That is what he's saying. That
My
is
lord,
what.
I have nothing to say. If your affidavit takes a stand by an officer saying that this is not, it has not been done, your name has not been included, and he is agreeing to what the, I have nothing to say, my lord. I
That-
close this argument.
That is what I'm
Yes,
asking
my
you.
lordship can note down that, my lord, that point, what my lord is.
There on record.
That's there on record. Where
Let me see.
page?
My lord, the page 223, man.
223 of, my lord is taking up WBC.
The second one, the fifth.
623.
Para 6, I think, affidavit 203, 205. Of the
205.
affidavit,
Ah,
which your lordship is reading
Yes.
at para 6, kindly see, my lord. Next, my lord.
correct. It's
Not
not
clear.
shown.
Not so. Now, my lord, what it means, my lord. I don't mind, my lord. Let him say, my lord. His own statement, my lord.
But then now he has stated that you have stated, you have not stated that, you sat together.
Regarding the feasibility, we are constant.
That-
We only say that during the study, his petrol pump was not taken into consideration.
So, but just now you said something else.
No, my lord, I said that his petrol pump was not taken into consideration.
But then
when the-
did you consider the feasibility report?
My lord,
We see the feasibility report was placed before all the three,
all three, my lord.
Okay,
Then they
and-
proceeded with the.
and you did not object to it. Is it? I don't know, I'm asking you.
My lord, that part is not there, my lord. in
Then
my
why did you say yes?
I'm sorry, my lord, but my instruction is, and whatever I have stated in the affidavit is in the same line as what I have replied to the petitioner and what he has annexed as an annexure, my lord. Is that his petrol pump was never taken into consideration in the entire feasibility report.
Yeah, okay, just let me see the other.
The very
petition.
last page, my lord, 185.
In the other writ petition. In the other writ petition,
My lord, the 6192, my lord.
yes, 6183. What have you stated here?
My lord, can you take up 6192, my lord?
No, 6183. You have said.
Yes, 203, my lord.
223.
Yes, 203, last page, my lord. The report is attached with the letter. In the report, Kendra and MS Yogi Gopa filling station situated at the same trading area is not restricted.
Mr. Council, 203, what are you talking about? Huh?
Like 223, man.
223, what are you talking about?
Oh.
Yes, what to do? Only one aspect. Because you have said that after the feasibility report was made, it was placed before all the three oil companies, and they did not object to it. And subsequently, as there was no objection, you all have you have published the advertisement. Correct?
Yes, ma'am.
Only on that aspect. You just you just find out from your clients. When can you find out?
That is in the marketing.
Huh?
It is in the marketing manual, madam, as to how it is to be.
Hey, again, what he's saying, your lordship is asking something else.
Huh.
Very clear, your lordship is asking. That you said that three companies said and feasibility report has been furnished. So your lordship is asking my learned friend, where is that feasibility has been furnished or not? If it is furnished, end of the matter, my lord. That's what your.
Whether
lordship
it
is
is,
asking.
yes, the furnish and whether you did not object to it.
Yes, that's all,
That's all.
end of the matter.
If that is there, then the end, then he's got nothing to say. Okay,
What I will say then thereafter, my lord, that's
Yeah.
my case.
okay, right. Heard Mr. D. Das, then a senior counsel, assisted by Mr. K. Burman. Also heard Mr.
P. Bharadwaj,
P. Bhardwaj for the
respondent number 4 and 5.
point number 4 and 5, and Mr. S. But Thakur for
Number 3, madam.
that's point number 3. Full stop. The petitioner is aggrieved by the feasibility report dated, what is the date? 5/11/2018, is it?
Yes.
15/11/2018. On the basis of which advertisement dated, where is that advertisement?
There is a date is not there, my lord, in advertisement.
Advertisement dated nil,
Yes,
page,
page 135. Page 135.
advertisement dated nil,
25/11.
25/11. For, huh? 25/11/2018. For appointment of regular/rural retail outlet dealerships was published by the Bharat Petroleum Corporation Limited.
Page 138 is the pump. 78 serial number.
First off, the retail petrol pump outlet that was to be that was to be constructed was with regard to serial number 78. No, was with regard to the location at serial number 78. That is, what is this location number?
This is your lordship will find at 138 on Patilia Doha.
On part at 78,
Yeah.
on particular sources. Full stop. Full stop. The petitioners, the petitioners council submits that the petitioner has a petrol pump in the said area in the name of, where is the name?
Yes, my lord will find.
Page 31.
31. In the name of
Patihala
Amount of Kisan Seva.
183, your lordship will find the name.
183.
183 on the top. Patila Daha at page 183
In the name
on the
of,
top.
at top, it's there. Pala, what is this?
Patila
Patila, Daha,
Ananta KSK.
Ananta KSK. He submits that for opening up of a new retail outlet, the government of India, Ministry of Petroleum and Natural Gas had issued a letter number P-19011/5/2010 IOC dated 6/4/2011 to the chief executive officers of the Bharat Petroleum Corporation Limited, HPCL is Hindustan Petroleum Corporation Limited and Indian Oil Corporation. In terms of the said letter dated 6/4/2011, a feasibility study was to be made by oil manufacturing companies for opening new retail outlets, wherein the appropriate returns for financial viability of a new retail outlet which form the gross margin available to OMCs on MS/HSD is rupees 354 /KL, page 148, para 1. He also submits that the oil manufacturing companies may work out a mechanism. It says may work out. May work out a mechanism
Sometimes may has to be construed as a.
where the ED means
Executive director.
executive director bracket retail of the three OMCs may decide by consensus on expansion of network in new areas like developing suburbs in cities, new highways, road bypass, etc. He submits that while the respondent number 3 had issued a notice for opening a new RO in a rural area near the location of the petitioner's petrol pump, by way of by way of a feasibility report, by way of the feasibility report dated 15/11/2018, the said feasibility report does not make a mention of the petitioner's petrol pump. As such, the respondent number 3 should be directed to make a new feasibility report in which she has to consider the location of the petitioner's petrol pump and thereafter consider if it would be feasible to have a new RO. That's all I think. That's your case. Next paragraph. Mr. S. Thakur, the learned counsel for the respondent number 3, submits that the letter dated 6/4/2011 issued by the Government of India, Ministry of Petroleum and Natural Gas, wherein it is stated that the OMCs may make out a mechanism for expansion of their network.
B-side.
Huh?
We are going to construct B-side location, my lord, instead
Yes,
of.
network. Whatever I said, I've lost track.
Mr. S. Bothagur, counsel for the respondent number 3, submits that the letter dated 6/4/2011 issued by the Government of India Ministry of Petrol and Natural Gas, where it is stated that the OMCs may make up
On expansion of network, is only a guideline which cannot be enforced in the court. He further submits that the opening of a new RO by the respondent number 3 in the vicinity of the petitioner's petrol pump does not violate or infringe any of the petitioner's legal or fundamental right. He accordingly he thus submits that the petitioner, that the writ petition should be dismissed as no legal right of the petitioner has been violated. Full stop. Next para. The counsel for the respondent number 3 also submits that as per the agreement, memorandum of agreement entered into between the petitioner and the Indian Oil Corporation, bracket respondent number 4, on 23/11/2015, comma. The petitioner had agreed not to dispute, comma, object or to challenge the appointment of other dealers at the same place or at any place either by the corporation or by any other oil company or corporation for the time being operating in India. He submits that as the feasibility report dated 15/11/2018 made by the respondent number 3 had been placed before the HPCL, before the authorities, before the HPCL and before the IOC, prior to issuance of the notice for appointment of retail outlet, rural retail outlet dealership, comma. The petitioner was stopped from making a challenge to the petitioners, to the feasibility report made by the respondent number 3 and the consequential advertisement issued by the respondent number 3 for appointment of rural retail outlet dealerships pertaining to pertaining to Om Patil so and so, page 138, serial number 78. Okay. Then, Mr. That's all, I think. Anything else? Nothing else.
They objected only because the para 11.
Para 11.
Yes,
No, that's all right. That is your case. Anything else? No. Mr. P. Bhardwaj, learned counsel for the respondent number 4, submits. What do you submit?
Retail outlet was not taken into consideration while carrying out the feasibility study.
Submits that the
Retail outlet was
the petitioner's retail outlet was not taken into consideration by the respondent number 3 while making the feasibility report dated 15/11/2018. What about the fact that he says that it was brought to your notice and you obtained instructions or
that part I don't think so.
for when you obtained instructions, right? On considering the submissions made by the counsel for the parties, this court directs Mr. P. Bhardwaj to obtain instructions from the respondent number 4 as to whether the feasibility report dated 15/11/2018 was placed before the respondent number 4 and whether they were in the knowledge that the notice for appointment of regular/rural retail outlet dealerships dated so and so, He shall also specifically state as to whether the respondent number 4 had objected to the feasibility report made by the respondent number 3. List the matter when? Day after? This is the matter day after.
11, I have got some special bench of Mizoram, my lord, that's a medical cases, we whole day will take, my lord.
This is the matter on,
After that week, my lord.
16,
Yes.
16,
It is a part of.
as part of it.
Deeply opposite.
That's the small issue. only.
We are very narrow campus. Deeply opposite.
Yeah, just take this, put this on. Bench three matter.
My lord, because bench matter, my lord, other code cannot be taken up, my lord.
Oh, that's why it is here. Oh,
Then it was listed to the bench form, my lord. That's why it is listed within your law.
what is the matter about?
Matter, my lord, petitioner page 26 of the writ petition decision, my lord. I was placed under suspension
Yes.
under rule 6(2).
Rule 6(2).
Rule 6(2), my lord. Deemed to be suspend because of the criminal case, my lord. Thereafter, my lord, I made a.
When?
That was, my lord, issued on 2nd August 22.
You are arrested,
I was arrested on 29/7/22.
arrested on 29,
7/22.
29/7/22,
Then, my lord, they have suspend me, my lord, deemed suspension on 2nd August 22.
deemed suspension on 7th August.
2nd August giving effect. my lord.
7 August 22 with effect from 29/7.
Yes, my lord. Thereafter, my lord,
Which page is that?
at page 26.
Then,
Then, my lord, I was enlarged on bail on 14/9.
page,
14/9, lordship will see in my representation, page 29, my lord.
enlarged on bail on 14/9.
22.
Then,
My lord, I have approached to the authority, my lord, in the light of Ajay Chaudhary, my lord, 90 days has to be
when
there.
did you approach?
I have approached to the department.
When?
Department, my lord, I have approached on 2nd August 22 at page 30.
2nd August 22.
Oh, sorry, my lord, 30 September 22.
30 September 22. So
At
this
page 20.
3 months have not elapsed.
My lord, thereafter, again, I have approached, my lord, 21/11/22.
21/11/22.
Seeking, my lord, reinstatement, my lord. Now, my lord, department has filed an affidavit, my lord. It seems, my lord, within the period of 90 days, they have not reviewed, my lord. Lordship, kindly have a look.
They have not reviewed.
They have not reviewed, my lord. From their own admission, my lord, lordship will take up at page 59, my lord. Date of issue is 19 December 22. Page 59 of their affidavit.
Yes.
May I read, my lord? Whereas Srimati so-and-so, the then superintendent of excise Morigai was placed under suspension by order dated 2nd. Whereas the memorandum of charges has been served on DD, department proceeding against the petition is continuing. Whereas it is decided the authority that the reinstatement of the so-and-so is a violation of so-and-so interest of public. So now, therefore, governor is Assam pleased to extend the suspension, my lord, with effect from 29/10/22. Meaning thereby after 90 days. Date was issued on 29/10, my lord, expired 90 days, completion of 90 days. Extension was given, my lord, 19/12/22. Lordship, kindly see the bottom page, my lord. Now, my lord, they said, my lord, the Ajay Chaudhary is not applicable. Accordingly, my lord, I bunch of judgment I have annexed in my additional affidavit, my lord. Reply, my lord. Lordship will see the division bench order and Rakibuddin, my lord. Lordship kindly turn to page 77 is the judgment of division bench, my lord.
Yes.
Lordship may be aware, my lord, the Mirgen Haloy. 90 days, my lord. Thereafter, my lord.
Where does it say?
Yeah, and there are 20 and 21. my lord. 20 and 21, my lord. Thereafter, my lord, another division bench order, my lord.
Just a
Lordship-
minute, just a minute.
Lordship. Hmm. 21 is very clear. man.
Yes, then,
Then lordship will see another judgment, my lord. At page 84, this is also division bench judgment, my lord.
yes,
Operative part, my lord, lordship kindly turn to my lord. Kindly turn to my lord, para 16, my lord, at page 93. Narrate, my lord, small paragraph, page 93.
yes,
The decision of the case of Rajiv Kumar Supra does not lay down the position of the law order of the suspension would not call for the review. Therefore, the decision of the, in our opinion, must be understood to have the rendered the facts and circumstances of the case. On the other hand, decision of Ajay Kumar Chaudhary is of the important and hence would be applicable in order of suspension, more so in view of the categorical findings coordinate bench of the Rakibuddin so and so holding the ratio of residue would be applicable to the order of suspension, rule 6(2). I was placed on the rule 6, the permission, so and so. Then my lord, the applicant counsel also failed to pursue that the view taken by the Rakibuddin Supra calls for a reconsideration by a larger bench. Then my lord, Rakibuddin, I have annexed, my lord, at page 95.
page,
95.
what is this?
My lord, honorable single judge, because of the applicability of Ajay Chaudhary, my lord, referred to the division bench. Then division bench said, my lord, they are found by 90 days, my lord.
Page,
That lordship will see it starts from 95, my lord. Operative part 101. Of paragraph 1500, my lord, paragraph 100, page 100. We have seriously applied our mind to this court by the learned single judge Ajay Kumar Chaudhary in the case where the suspension order is royal of the department in the case of the deemed suspension observation by the so para 20 of the analysis section has been brought in your view of the whole that the principle laid down by this is could so and so restrict the order of the suspension so and so. In our view, the case would have been from the superlative conservative and effect of the suspension is the same, both cases. We do feel it no prejudice would be however caused to the department by the interpretation in as much as the blanket order of revocation suspension is passed in the department to make periodic review within the 3 months. Decide to whether the suspension is required to be extended or not by the saying so. In the view of the aforesaid discussion, we answered the reference by holding that the principle laid down Ajay would be applicable in case of deemed suspension under rule 6(2). I was also placed under suspension grades 2. Then lordship will see the honorable single judge order which went to the read appeal. That your lordship will see page 102, annexure 4. That my lord operative part operative part. Operative part, my lord, para 114. Against which they have gone to the division bench. Page 114. In view of the facts and circumstances of the case, it has not to put the follow the decision of the Rekibuddin Supra accordingly the order of suspension, which was reviewed with the 60 days and as now the showcase notice has been issued, set aside and passed. This is the like to the observation, there is no prejudice whatsoever would be caused department in month the blanket order revocation of so and so. Is left to the department to make a periodic review within a period of 3 months from then to decide so and so.
Yes,
Now, my lord, the question is that, my lord, they have filed an affidavit, they said, my lord, we have taken recourse of rule 6.1. 6.1.
6.1, 6.1.
6.1 says, my lord, 6.1 is says, my lord, for the, I'll just read out, my lord, 6.1. 6.1 says, my lord.
Give me 6.1.
Some disability appeal rule, my lord, lordship can have a look my book also.
Yes, there is no, just read it first.
Suspension, appointing authority or any authority to which is the subordinate to the other authority empowered by the governor in that river may place a government servant suspension. A, where the disciplinary proceeding against him is contemplated or is pending, where the case against him or in respect of criminal offense involving the moral tripartite is under the investigation or trial, provided that where the order for suspension made by the authority lower than the appointing authority, such authority.
I don't have a problem.
Lordship can have a look, my. It will on.
So what is the difference? What is
My
that?
lord, I was placed under such a difference, my lord, they could not have projected. In their affidavit. Now, my lord, once, my lord, during course of the trial, they said, my lord.
They are saying that the suspension will be made under 6.1.
6.1, but document says 6.2, page 26.
Then they cannot go beyond the document.
They cannot go beyond the document.
The appointing authority. See, 6.1A.
They said only 6.1.
Yes, so how does it matter?
My lord, is the
Yes, Mr. Council. Even if he's suspended under 6.1, he's suspended under 6.1A or 6.1B. Let us, huh?
6.2, page 26.
Page 26.
Page 26, a lot.
Page 26.
Of my read petition.
Six two. But assuming he's been placed under suspension under 6.1 also. Then what is to be done?
Lordship is completely relying on the judgment of Ajay Kumar Chaudhary, Your Lordship,
Yeah.
whereby says 90 days is mandatory for review. But here, the coordinate bench held that.
Huh?
Coordinate bench of this court has held that. What happens when so reviews not done within 3 months if the delinquent officer is in custody? When we have served the show cause notice on Lordship
10 December.
or Lordship.
If he's not in custody, if he's in custody.
If he's in custody, if he show cause, he has not received a show cause or Lordship, then what happens? In that case, I place one judgment, Lordship. WPC 455/2023.
Yes.
How much has been
At para 20, Your Lordship.
Para 20.
Yes, Your Lordship. May I read, Your Lordship?
Yes.
A very pertinent question therefore arises as to from which period the direction in paragraph 21 of the judgment of Supreme Court in the case of Ajay Kumar Supra shall apply in the case of deemed suspension. It would seem that the judgment of division bench of this court in the case of Rakibuddin Ahmed Supra, however, with due respect, did not deal with this question, and in fact the same can be unraveled from the provision rule 6.2 of the rule of 1964. The provisor speaks upon the following condition upon which appointing authority may vacate a suspension order from the government servant is released on bail or is not otherwise in custody imprisonment. Then the condition are given lordship, then below lordship. However, upon applying the judgment Supreme Court.
Just a minute, wait, just a minute. They are where the detention. Yes.
Thereafter, however, upon applying the judgment of Supreme Court in the case of Ajay Kumar Chaudhary and judgment of division bench of this court in the case of Rakib Buntin, the fourth condition can be called out. Where the memorandum of the condition is where the memorandum of charge sheet is not served upon the delinquent officer employed within 3 months from the date of release on bail or release from in custody or imprisonment. And if the memorandum of charge sheet is served, a reason order must be passed. Now the question therefore arises that when the above mentioned condition can be taken into consideration by the appointing authority. In the opinion of this court, condition above noted can only be taken into consideration when delinquent officer employee brings the fact that she has been released on bail or otherwise not in custody or imprisonment to the appointing authority who has a power to vacate a suspension order. Here, Lordship, the petitioner was released on bail on 14th. If I'm not wrong, Your Lordship, he was released on bail on 14/9/2022. Page 28, Your Lordship. He was released on bail. Thereafter, the petitioner informed us on 13th September, Your Lordship. So assuming he has not received the show cause notice which was sent him before, he has informed us that he was released on bail on 14th. We got the information. 14th/9/2022.
14/9/22.
Yes.
So
Thereafter, we came to know about his release from the custody on 30/9/2022. So thereafter, we can count
on 39.
30. So counting from there.
Not technicality. You see, the person who put him in jail is a part of your government itself.
Yes, Lord.
Your right hand should know what your left hand is doing. You cannot say that just because I don't know what my left hand is doing, that portion of which my left hand is doing has to be ignored. How can it be done?
But we have served him during the time of the suspension period, within the time. But he is saying that I have not received a show cause notice because he was in custody.
He has not received a show cause
Yes,
notice.
he said he has not.
When was the show cause notice issued to him?
Show cause notice was issued to him, Lordship, on 2/8/2022.
Okay, 2/8/22. Okay.
I was behind the bar.
Exactly, Your Lordship.
Okay. Show cause notice was issued to
Yes,
him
Your Lordship.
in 2/8/22.
Yes, Your Lordship.
Within the 90 days.
Within the 90 days. Now, Your Lordship.
But it was not received by him
It was not received by him.
because he was in
He
jail.
was in jail. And this order which I have given to Your Lordship clearly says when a delinquent officer informs the authority that he has been released from jail and then he receives the show cause notice, that's from that period, the 3 months counting starts, Your Lordship. If I take my Lordship affidavit of opposition, we have filed page 63, Your Lordship.
We'll have to. I
My
think
lord, I'll
it did.
clarify, my lord. The
No.
same coordinate bench passed another judgment, my lord. I have same coordinate bench, my lord. Ajay Chaudhary
Just a minute.
received on 10 December. Same coordinate bench says, my lord, 2 judgment. Ajay Chaudhary is applicable. Ajay Chaudhary 2 judgment, same court. Recent judgment, my lord, I'll download it. That said, my lord, Ajay Chaudhary is applicable.
Will apply.
Apply, my lord. I have given copy. He is also appearing, my lord, Forest Department. And one is CS, my lord.
So you mean to say
90 days is mandatory.
there's a contradiction between the two judgments?
My lord,
Passed by the
cannot
same
say, my
judge.
lord, I am afraiding, my lord. Lordship will see from the record.
You are afraiding? What is afraiding? What
My
is
lord,
that
I
word?
cannot make any comment, my lord.
Yeah.
I cannot make comment.
Don't murder the English
No,
language.
my lord.
As it is, our English is also going from bad to worse.
Lordship. I cannot comment on that, my lord. There is a different judgment. Lordship.
Taking into account the above and
I mark most point.
the first suspension would be done. No, but why was show cause? But show cause notice was not given to him. That is the issue.
Yes. He did not receive the Lordship. We have submitted him, he did not receive. On 2/8 we.
Where did you give it to him? In his house, in his residence or something? What do you mean you give it to him, but he did not receive? I don't understand. You see, if he rejected the said show cause notice is deemed service anyway. What do you mean by saying that we gave it to him, but he did not receive?
We sent it to lordship, but since he was not there, we sent it to his residential area.
You send it to his
Yes,
residence.
since he was not there, he said
Okay.
he did not receive it.
Okay, that's a question of
Yeah.
fact.
Yes, Lord. He said the petitioner said.
What
"I was-
did you send it by way of registered post with AD?
Sorry, yes, lordship.
Huh?
We have.
Because in that case, there could be deemed service also. Under the General Clauses Act. And maybe under proviso to rule
Order 5.
5, sub rule 9 of rule 5.
Something. Order 5, rule 9. Listen. Okay. General clause 27.
Yes.
Lordship, if I may take the affidavit in opposition, we have filed in lordship, page 63.
You see, I'll have to read these judgments.
Yes, sir.
Page 50,
63.
63.
Yes, sir, lordship.
Yes.
Learned counsel so and so responding excise department produces show cause notice dated 23/8/2022 under rule so and so, by which a disciplinary proceeding has been initiated against the petitioner. Mr. So and so also brought on record communication 8/12/2022 from the Additional Commissioner of Excise, Assam, to the petitioner, giving her reminder to submit reply pursuant to show cause notice dated 23/8/2022. Both the communication kept in record. These are the 4 weeks and so on so. Last paragraph, lordship. The respondent may provide GI learned counsel for the petitioner, learned counsel for the petitioner, copy of the said show cause notice, and the same under law to be understood that the show cause notice has been served on the petitioner.
So basically, there is a question of fact as to whether he received the show cause notice or
I
not.
have given copy, my lord. Date of receipt copy, I just now have given.
That is a different thing. You'll naturally make it after 3 months.
We'll see from the record.
Then we will
Yeah,
know, we'll have to see.
Here the question lies, lordship, whether the purported access has been completed in 3 months or not. That's
Correct.
the main question, lordship.
No, one thing you can clarify, whether you sent it by registered post with AD, how did you send it?
That may I think clarify, lordship.
You have to clarify that. You clarify that.
Well,
Okay, right. Heard Mr. Jai Burbuyan, learned counsel for the petitioner. And Mr.
R.R. Gogoi, lordship.
R.R. Gogoi, learned counsel for the excise
Excise
department.
department, lordship.
The petitioner's case is that he was arrested by the police. By the police on 29/7/22. And by notification dated 2/8/22. The petitioner was placed under suspension in pursuance to rule (6)(2) of the Assam Services (Discipline and Appeal) rules, 1964. With effect from his date of detention, that is 29/7/22. The petitioner was enlarged on bail on 14/9/22. And the petitioner approached the respondents on 39/22. For what? For
reinstatement.
39/22 and 21/11/22 for reinstatement. The petitioner's case is that as the show cause notice was issued to him only on
Only on 10/8, my lord,
10/8.
2000, no, my lord, 8 December, I have given copy, my lord, lordship, can you pardon me, my lord?
Affidavit in opposition, page 6, he saying.
It was only on 10/12/2022.
10.
That is beyond the 90 days period provided by the apex court in Ajay Kumar Chowdhury versus Union of India, reported in 2015, 7 SEC 291. And the various division bench judgments of this court, wherein it is provided that, wherein it was held that the judgment of the apex court would apply to deem suspension, the petitioner should be reinstated into service after dismissal of, after setting aside the suspension order. The petitioner's counsel submits that no review of the petitioner's suspension had been undertaken by the respondent authorities within the 90 days period required, as provided by the apex court in Ajay Kumar Chaudhary Supra. That's all, I think.
My lord, that
Next.
they have annexed also, my lord. to that.
Mr. R.R. Gogoi, the learned counsel for the excise department, submits that the petitioner, that the show cause notice was issued to the petitioner on
23rd August 2022, your lord.
23/8/22. How? You don't know.
That happens.
By way of, as such, show cause notice having been issued prior to completion of 90 days from the date of his suspension, the case of Ajay Kumar Chaudhary Supra would not be applicable to the facts of this case. On considering the submissions made by the counsel for the parties, Mr. R.R. Gogoi shall produce the official records and indicate as to the manner in which the show cause notice was sent to the petition. List the matter when.
Next week, your lordship. Any date next week.
Friday, my lord.
Huh?
I'm suspension, my lord, no job, nothing, my lord. I'm going to retire also.
What case? What case? Under section what? Your section is under what? Criminal case?
Criminal case, my lord, anti-corruption,
Anti-corruption,
taking bribery.
Taking bribe.
bribery.
Bribery, said my lord, case is that, my lord, I should not say, it was kept in my bag, my lord, in a trapping way.
How much was kept? How much was kept?
20,000, my lord,
20,000, so
Right.
little.
20,000.
It was kept in your bag.
In your bag on my table. I became
Oh, on the table.
table, my
And
lord.
what were you doing? Having chai?
My lord, I have got, my lord. I have
No, no, what were you doing when it was
I
put
was
in your
working, my
bag?
lord.
You were working
I am working and meeting other persons.
and then someone put the
Someone put
money,
and immediately came.
he put it and went out.
We went out, immediately the police came. to
What
us.
is it? Okay.
Nexus, my lord, something like this. Friday, my lord.
No, I don't have time.
Lordship.
This is the matter after
A date, may
after a week.
any date, lordship fixed. my lord.
Huh? 18? No, wait, I don't know. 23rd.
My lord, 23rd, 22nd to 24th, I'll be out of station. Any day before that, my lord.
25th.
May Mahan. 25th. Can it be 18, my lord, subject to lordship's convenience?
We have fixed matters. That's the
Lordship, I was
problem.
there, I know.
We have fixed certain matter. I don't know if it'll reach. And this I've got to read. So this bench has passed two contradictory orders.
Lordship. And he was the one who's the appearing for respondent in both the cases.
So I have to see.
Lordship.
No,
can-
I
Lordship
have to
can
see.
take them.
So if there's a contradictory order, I
Lordship.
mean, then you should have brought it to the notice of the court
But
that it should have been, it should go to the division bench.
that order I'm not aware of, your lordship.
এই যে মোট দেখাই এই যে তোমার ফরেস্টর যেতে যে শিলচর
I have to go to.
I don't know.
Grogoy and something.
Which one?
Two, my lord, I have marked.
Ah.
One is Devabrata Gogoy and another
One Debrata Gogoi and one is
Morigao district.
No, there's so many, there are three judgments. One is WPC 2127 of 2023. Yes, you can write
I'll
down.
supply my lord, I got in my mobile, I'll forward.
Give it to him.
Only my lord, I may.
One is WPC 1676 of 2023 and one is 455 2023.
Yes, I'll supply, I got a mobile.
I have given, 455, I have given.
455 you have given.
Yes, a lot.
So the others are 2127 of 2023 and 1676 of 2023.
But only I may be permitted to take my lord copy of the show first.
Sure, this one.
This one.
Yes, yes. This is also a photocopy.
My lord, I do not have anything for my.
This is the matter. On
Yes.
24, lordship. After
He is
any
not
day,
there.
your lordship.
Okay, we can try 18, but I don't know, huh?
My
18. You have to take back this book also.
Lord.
I think I'll take these judgments. I just want to see the difference. One 4 you have this 455.
455, your lordship.
And this and your one is which
I
one?
have given
Both.
two.
Both same like same
Same day judgment, my lord, same code.
and which is opposite to
Yes, my lord.
which is counter to the 455.
Yes, my lord. Both the cases got arrested and honorable single judge said, my lord, the Ajay Chaudhary is applicable.
No, but then the question was whether they were served with the copy,
No,
the
my
show cause notice prior
No,
to
my-
the 90 days.
Lordship will see, my lord, preliminary idea, small word.
Okay.
Lordship.
All right, lordship.
Mr. Goswami, you should have mentioned it in the morning, your item.
My lord, it was quite high up compared to the other day, list of for the other days, my lord, and I thought actually I made an inquiry with the bench assistant in the morning. And then I was waiting, there was some matter in the other courts.
Because I completely forgot. I just remembered your case. Because this.
Anyway, even now, if I get an order, my lord, all I wanted, my lord, let it be subject to the writ petition. I cannot get out of it.
What is your case? Just give me a short.
My lord,
But where is, again, now we need the forest department also. Yes, what is the matter?
my lord, matter is like this, my lord. I am settled with two fishes,
Ah.
two mahals, my lord.
You are only bothered with Dudnoy.
One, Dudnoy, my lord. Now, Dudnoy I was given in October, my lord. First is
October when?
22.
October 22.
Yes, my lord.
Yes.
So that first case, the first installment, my lord, that was to last till January, man.
First kiss was to be paid when?
In October.
October 22.
No, October, I was given possession on 13. Before that, I paid. I had paid that first kiss.
You have paid the first kiss.
I paid. the
What
first
have you
kiss.
not paid?
My lord, second kiss onward, my lord.
Second kiss was, when were you supposed to pay the second kiss?
Sometime in January
January of 23.
23.
So you have not paid second and third kiss.
No, my lord. The reason is there is no sand left in that because of large scale settlement of mostly illegal without tender and pata land settlement, my lord, upstream in the river, for which, my lord, there was not no sand flowing to my mahal, my lord. Now I filed the writ petition, my lord. My lord, on the basis of my representation for surrendering the mahal
Surrendering Mahal when?
in December, my lord.
When?
December, my lord, I will just. My lord, that is dated 10/12/2020.
10, 12,
2022.
22.
Yes, ma'am.
Then?
Then, my lord, the matter was pending, my lord. They didn't pass any order and they filed affidavits here. My lord, pleadings were exchanged. Now, in their affidavit, they want to say that they have passed on the order on this man. That I'll.
They have passed order on their surrender application.
Yes, my lord. That they do not say. They said on the petition filed by the petition.
What petition? What
No,
petition?
no date is given. Nothing.
No, what is the order? Show me the order.
Yes, ma'am. Yes, my lord, that will be it. The affidavit filed by them, my lord. 9/2/2023. Affidavit in opposition. Page 71. Para 11. Had your lordship, Para 11, my lord. That as regards
71 is annexure 1.
the annexure H, my lord. That is of the affidavit, my lord, filed by them, affidavit in opposition. Filed by the respondent.
Affidavit of position filed by the respondent number 5.
Yes, ma'am. Respond number, it is not mentioned. Yes, my lord, respond of 5. Jurisdictional dear.
Page 71.
Page 71, my lord.
Page 71 is
Your lordship kindly come to page 11, para 11.
11. Yes.
That as regards the non-consideration of the representation dated 10/12/2022, it is totally denied. As the principal had in response to sought a detailed reply to which the deponent had filed reply by his letter dated so and so. They say detailed report contains the reason behind such non-entertainment of his prayer on a positive till. Now your lordship will kindly come the annexure. Page 92. Annexure H. He is relying on this man. Has your lordship? Annexure H, page 92. May I please your lordship? Now your lordship will kindly see, this is an internal
sir.
letter. This is an internal letter. From R5 to the Chief Conservator of Forest.
Yes.
Subject your lordship will see regarding prayer petition submitted by Sahabul Islam. There is no date, nothing, madam. We can't link it to anything. Madam. Inside also I have gone through, my lord, but there is no reference of that petition, madam. At the end, my lord, he says, my lord, this. My lord, page 94, my lord. Thus, on the basis of the above facts, it can be considered prayer petition of the Sahabul Islam has no any merit. So I have the honor requesting no demand of Islam shall be accepted. In fact, but there is no reply on my prayer. He is harping on my lord, non-payment of my kiss, my lord, and he says that I bid very high. That's why I couldn't pay. But it provides, my lord, there is no, my lord, inspection carried out whether there was any sin left in the mahal or not. And I have, after January, my lord, I am that, my lord, period, my lord, I am also not running the mahal, my lord. The first kiss period, my lord, once it expired, I stopped. I haven't been extracting any sand there from me. But there is no inspection and there is no reference in this letter also. So how can we conclude that, my lord, he has, my lord, considered my prayer or passed any order there? So ultimately, my lord, these issues have to be decided by this honorable court, my lord. That is my limited understanding. But in the meantime, my lord, this tender has come up where I am interested in. So all that I am praying is that I may be allowed, let it be.
No, let me ask you one thing.
Yes.
Now, you want, they have submitted they have issued the tender for the Dudnoi. Again,
Two money.
a different.
Different.
Yes, Mr. Goy. He says that he wants to
What is
participate.
the default, lordship?
He's a defaulter. Even the clause says, he's challenging the clause which says that a person with default cannot participate in lordship. Cannot.
Correct. No, that is all right. Huh?
Here, my lord, but the
Huh?
court has to decide, man, those things.
No, one thing is, this he said that his application for surrendering the Dudhnoi Sand Mahal has not been decided till date by the forest department. Has it been decided?
For that, I'll take the lordship. Want the rules, your lordship.
No, what rules?
There is a procedure for surrender of the lease, your lordship.
Correct. He has to maybe fulfill 3 conditions.
Yes, your lordship. That
Then,
condition he has to fulfill. There is
so where is the order saying that his
madam. It's
application is declined or rejected or allowed?
no order for that, your lordship. There's no signing any order.
Huh?
There's no order. Yes.
So what he's saying is that if no decision has been taken on his application for withdrawal from the Sand Mahal, he should not be barred from participating in the other tender.
But since there's a clause on,
Huh?
since there's a clause, your lordship, that clause we have to follow, your lordship. Since a defaulter, he's not submitting the case money.
Oh.
And written, he has not even signed the agreement
He has
also.
not submitted the case now.
He has not signed the agreement also.
Yes. There is one thing, if you do not submit the kist money, then
No, well, that they are incapable, they have not passed any order on that. Your lordship has to decide that issue. Why
No.
I did not pay, this is prior, my lord, my submission for surrender of the Mahal, my lord.
you see, for whatever reason, you have accepted the Mahal.
Yes, my lord. It
You
is
and
provided
you
under the law, my lord.
and you have said that you will pay this amount. Whether you can extract that amount of sand or not, that is your risk. If you can extract
lord,
more,
my
you can,
My lord, it is like this, my lord, the
Ah.
surrender is provided for under the law itself, my lord. If it is not feasible to run, my lord, so they have to carry out an inspection of the Mahal, whether.
but it is discretionary power.
Maybe, but I am entitled to an order, my lord. I pay 70 lakhs, my lord. One instance, 70 lakhs. My security money is lying with them.
Then
And I'm not, it is not that I am operating it and I am not paying. I inform them and I stop operating because there is no sand. Only in that context, my lord, I am making this prayer. Actually, there is hardly any time left, my lord. 5 o'clock is the last time. And your lordship can hear the matter on a short date, my lord.
and your 2 trucks and your vehicle was also, you had a problem.
Well, those things are there, my lord. Those things happening, but you cannot, one cannot attribute it only to the Mahaldar, my lord. They are drivers, other people are involved, my lord. Those are police cases, offense report, they have to file in time. They do not.
Yes, where is the decision on the withdrawal application? You see, annexure H of your
Yes, sir.
affidavit. Whether this is the one. Caught his vehicle on several occasions for illegal transportation of sand.
From river to.
Huh?
For the shelter, mining station.
And your lordship will kindly, my lord. See one provision, my lord.
This will cover it because last line, last paragraph says that On the basis of above fact, it can conclude that prayer petition of Sahabul Islam has no any merit. So I have honored to request you to no demand of Sahabul Islam shall be accepted. In fact, request you to cancel settlement goodness and preview with immediate effect and blacklisting in 5 years from department, recovery of all the pending dues.
So now this prayer petition, this page in the last, it says that the prayer petition of Shabul Islam. How many petitions have you submitted to the authorities? Only that?
Oh, yes, madam.
Huh?
That and thereafter another, that is also an.
Where
One
is
of
it?
the
Let us
requirement.
see. Let us.
One of the
In fact, the prayer is completely
last,
different from what is
last.
submitted.
two
The
annexes.
prayer of the petition is completely different from what is submitted.
No, let us see out here. Let us see his applications.
My
If
lord,
that- if
page,
it has-
page 40 of the petition is the second one.
Page 40.
Yes, ma'am.
Page 40.
Yes, ma'am. That is also within the time of the first case period, madam. Here I have given one, my lord, instance of grant of extension of San Mahal, my lord, to one, who is also responded in this petition, my lord. One Mr.
So you, and what is the other petition that you have submitted?
My lord, the other.
How many letters have you given to the?
These two, my lord, annexus 6 and annexus 7.
Yes, yes. So these are both for, not for surrendering, it's for extending the period for paying kiss money.
No, my lord, the second one, my lord. The first one, your lordship, this is the issue, my lord. The issue is there is no send, my lord. Your lordship will kindly come to the last part, my lord. Page 39.
Yes.
At least allow the undersigned to withdraw from the contract respectfully by refunding his security demand without blacklisting him, my lord. And my.
Okay, this page 35
Yes,
is dated 10/12/22.
my lord, within the period.
And this is for withdrawing. Withdrawing,
Yes.
correct?
Yes, my lord.
And now your other
That is,
document,
that is 4/1/23.
that is on 4/1/23,
Yes, my lord.
that is for extending.
Yes, but if my area is extended, man, this is the prayer. These are the two petitions, my lord. They have not passed any order on either.
That is, you have. On the one hand, you are saying that you want to withdraw. On the other hand, you are saying that you want to extend the area.
This was given, my lord, when we came to know that this extension has been allowed. Normally, that is also not allowed, my lord. But when, my lord, we have given, my lord, that is respondent number. Your lordship, kindly see.
So this,
Respondent number eight.
so which one has been allowed? So which one has been decided?
They could have very well rejected
In
my
fact,
prayer.
as per my instruction, as per my instruction, lordship, he has never run this mahal. He has never operated his mahal.
That is a different issue.
Because he never came to agreement with the department.
Huh?
He
No
never came-
agreement.
No agreement with the department. He
There was
doesn't
no
come to
agreement.
agreement with the department.
You don't have any agreement with the department.
No,
My
lordship.
lord, I filed this case. This petition was moved on. I filed this case on 6th of January 2023. On 10th, this matter came up before this court, my lord, for consideration. The DFO himself, my lord, without any order from this court. And he could come, my lord, but normally it doesn't happen. The DFO himself arrived and appeared before the court, and he submitted a letter dated what, my lord? Dated 9th of January, the prior date, my lord. 1 day earlier, my lord. Only after they got the notice of this writ petition, they come out with the letter dated 9/1 saying that you have to come and sign the agreement. When the law requires that it has to be done within a period of 90 days, which was already passed. And now they say you have not signed an agreement. I am also not operating the agreement, but I have paid the kiss money. My security money is lying with them.
This is a government loss, law. We are losing the revenue, lordship. He doesn't come, he doesn't sign an agreement.
But he's extracting sand.
He's
No, I am not
he's
expecting,
not
sir.
expecting,
Only
he's
that
not
first
operating.
is that I have paid, my lord. Without saying I have not done
All
anything.
is lying
and I'm
idle.
not running, yeah.
Rule 22, your lordship, of the MMC rules, your lordship.
Huh?
Which rule 22 of the MMC rules?
I think we'll have to, I think we've got to. These are more issues that have been raised now.
Yes, your lordship. In fact, this is the second writ petition they have filed. They have filed another writ petition, your
That is
lordship.
the cause of action is different.
What is the, what are the other writ petition?
They
Another
was
Mahal.
challenging Rule 5, your lordship.
Huh?
Rule 5, which allows our government agency to extract sign, your lordship. He has challenged that, your lordship. He got a stay order that was vacated, your lordship. Thereafter, this he has filed.
But thereafter, my lord, my instruction is that they have stopped operating that Mahal, my lord. That is the current thing.
No agreement signed, your lordship.
But that is on a different issue.
This clearly says Rule 22(2) says if the contract agreement is not executed within the aforesaid period, the order sanctioning the contract shall be deemed to have been revoked at an advance contract money, and the security money deposit at the time of auction shall be forfeited to the government.
My lord, on one hand, you ask me to sign the agreement after 90 days, then you say, my lord, you have not signed the
Till
agreement.
date, he has not signed the agreement, your lordship. Till date.
My lord, this is on record, my lord.
But why are you not signing the agreement?
No, my lord. Things are like this, but they have never asked me, my lord. Only after I filed this writ petition, they received the copy. The petition was moved on 10. This very writ petition, my lord. And that they produced, the DFO himself had come and produced that letter dated 9/1, my lord.
He has been communicated, lordship. In our affidavit, we have filed page
Let
74.
me see.
Nothing, my lord. No, nothing on record.
Let me
Let
see
them
prayer.
show, my lord. Nothing on record, my lord. I am not making submission in here, my lord.
There is no prayer made by you that you should be allowed to sign the agreement.
My lord.
There is no prayer by you
My lord, at that point
that
of
you should be allowed to sign the agreement.
my lord, at that point of time, my lord, that was not the issue. It is for the authority, my lord. I do not prepare the agreement. I have to sign. That is done by the authority. My lord. They have to call me. They have to give me the agreement and they have to get it signed from with.
But then how come without the agreement you have been extracted?
Yes, my lord. Why they have allowed me? Why they have handed over the possession?
We have handed in possession at page 74 of affidavit. We are repeatedly asking him to come into agreement with us.
70?
Page 74 of the affidavit in opposition.
74 of the?
Affidavit in opposition
74.
filed by us, your lordship.
This pagination is completely wrong. Page 74, here is the affidavit in reply. Of the writ petition.
Of the writ petition, your lordship. No, of the affidavit filed by the department, your lordship.
I know,
Yes.
but then in the, they have changed this. I don't know. You just see which page.
My lord, this annexure is dated 9/1, my lord. 9/1/2023, my lord, after 90 days. And they are trying to rely on them. And before that, they have given me, my lord, they have accepted my payments and they have handed over the possession.
That is what page?
This is 74 carton marked as 50, your lordship.
50. That is the problem. Why you paginate as per this court pages?
Annexure A, that's annexure A, your lordship. It's regarding execution of agreement, your lordship. Under Rule 22(1).
What is the date?
There is not.
That reference you will also find in the para, my lord, statement. Page 68.
No, in my copy it's not 68.
That will be para
It is
6.
44.
Para 6 of that affidavit.
Whereas here is 9/1/2023 and 21/1/2023. From January till now May, your lordship, still hasn't come for executing the agreement.
You see, the problem is you were not here yesterday. You could
Yes,
have obtained instructions as to whether this document Page, what is this? 94 or what is this? I don't know. 68. No, for you, it will be 92, I think. Whether this is relating to which of the applications? There are two applications by the petitioner.
That is also not an intimation to me, madam. That is an internal communication.
That's the internal. Where is the letter that, where is your letter to him saying that your applications have been rejected? Okay, right. Heard, Mr. V.D. Goswami, learned counsel for the petitioner, and Mr. R.R. Gogoi, learned standing counsel for the forest department. For the petitioner applicant, for the petitioner applicant. The prayer of the, in the IA, in the IA. The prayer of the petitioner applicant is to allow him to participate in the,
My lord, Bhumuni, my lord, in the settlement process.
where is that?
And that is in my IA, my lord, page number. Page 15, my lord. Annexure 15, my lord, page 137. Annexure 15.
In the short e-auction notice
Yes.
dated 12/04/2023 pertaining to the Domoni River Sand Mahal number 1, Golpara. The petitioner, the applicant's counsel submits that the petitioner is presently having settlement of the Dudnoy River Sand Mahal number 3, bracket B. Full stop. Though the petitioner had given the first kiss money with respect to the Dudnoy River Sand Mahal number 3, bracket B, in October 2022, the petitioner has not paid the second kiss money, which was due in January 2023 and thereafter. Next paragraph. The petitioner's counsel submits. Now, the applicant's counsel submits that though submits that due to scarcity of sand in his mahal, the applicant had submitted a letter dated 10/12/2022 to the respondent number 2. To allow the petitioner to withdraw from the settlement of the Dudnoy Sand Mahal Dudnoy River Sand Mahal number 3, bracket B. The petitioner had also submitted a subsequent letter dated 4/1/2023 to the respondent number 5 stating that as there was no sand left in the mahal, he should be allowed to extract sand by extending the area of the mahal for a distance of 15 kilometers. The petitioner's counsel submits that the two representations / letters submitted by the petitioner to the state respondents have not been decided till date, inasmuch as no communication has been given or addressed to the petitioner with regard to the above two representations / letters. Full stop. The applicant's counsel submits that the petitioner has prayed for allowing him to participate in the online auction / tender process of the Domani River Sand Mahal, number 1. Full stop. However, in view of the fact that the state respondents have not taken any decision on the petitioner's representations / letters, and keeping in view that the petitioner has not paid the second and third kist of Dudnoy River Sand Mahal number 3B till date, the applicant apprehends that his offer / bid may not be accepted on the ground of non-payment of kist money. Next, Mr. R.R. Gogoi, the learned counsel for the Forest Department, submits that no agreement has been signed with the applicant petitioner till today with regard to extraction of the sand from the Dudnoy River Sand Mahal.
Lordship, I would like to refer to one of the rules of the MNC rules, Lordship, Rule 37, Lordship, and the order of Honorable Court 10/1/2023.
Just a minute, what have I said?
Mr. R.R. Gogoi, learned standing counsel Forest Department, submits that no agreement has been signed with regard to the applicant petitioner till today. Agreement has been signed with the applicant petitioner till today with regard to the extraction of the sand from the Dudnoy River Sand Mahal.
Yes, then what?
Rule 37 to your Lordship
Yes,
of the MNC rules, which says that the highest bidder shall be required to deposit an amount equal to 25% of the annual dead rent contract money as a security, along with additional amount equal to 1 month dead rent contract money advance.
37?
37 2. Thereafter, 37 3/1, your Lordship. On completion of bid process, that is called the hammer or opening of the scale bids, as the case may be, the highest bidder shall deposit an amount equal to 10% of the annual bid amount of initial bid security before expiry of the period allowed. And number 3, your Lordship, the letter of intent holder shall deposit a balance amount of bid security that is equal to 15% of the annual bid amount before the expiry period allowed. Now, Lordship, if I take your Lordship, the order of this honorable court, that is on 10/1/2023, your Lordship. May I read the Lordship? So-and-so, at paragraph 4, your Lordship, it is stated that the DFO who is present has produced a copy of the letter dated 3/1/2023, by which a request was made to the petitioner to sign an agreement. The learned counsel of the petitioner submits that earlier point of time, no request was made to sign such agreement. Be that as it may, today, the court when a copy of notice has been given to the petitioner to sign an agreement for a period which has already lapsed. The court is inclined to provide that in so far as interim refund earnest money is concerned, it will open the petitioner to approach DFO, Territorial, Walpur Division, if so advised. If so advised, and sign the contract agreement and claim the refund of earnest money. If such an application made, the respondent number 5 shall take appropriate decision notwithstanding the pendency writ petition. And as was my instruction, the petitioner, he approached the PCCF, not the DFO. And even a PIL was even instituted in this regard, your lordship.
Why are you not signing the agreement?
My lord,
You
your
want-
lordship, number one, my lord, that will not be 3-1, my lord, proceed. That was a typographical error. That will be 9-1.
Hmm.
Because that is what, that your lordship has just been taken through, my lord.
No, but whatever it is, subsequent to that, why are you not signing?
I was not running it, but payment 70 lakhs I have paid for the Kisma. That is the amount for
That is
including
gone.
security.
That is gone.
But this 9-1 is, my lord, the final, the law says from the grant of the settlement order, within 3 months, they have to give 90 days. I was made known, my lord, about this fact of agreement, my lord, before the court. Not even otherwise, my lord. Only after I filed the writ petition, my lord, seeking a prayer for surrender.
Even-
But then from that day, from 10-1 till today,
Yes,
Yes,
sir.
my lord.
you still have got time. So many months have passed.
But
4
I
months
was not
have passed.
running it from January, my lord.
Huh?
I didn't run it.
Executive agreement, your lordship. So
I did not run it.
agreement has got, even rule 22 says,
Huh.
last one provided that where the competent authority is satisfied that the LOI holder contractor is not responsible for delay in execution of contract agreement, the competent authority, for the reason to be recorded in writing, permit the execution of contract agreement deed.
The law requires that an agreement has to be made.
Yes, your lordship.
That requires, my lord. And
And-
that is to, my lord, within a period of 90 days, my lord. And
So that 90 days, it cannot be relaxed by the government, you mean?
it is not there, my lord. It is not.
Is there?
Where is, huh?
It's
Where?
provided that when the competent is satisfied,
Ah,
if
where-
the competent is satisfied, rule 22,
22?
rule below rule 22(2), provided that.
Yeah, it can be done.
And since he's a defaulter, if he even he submits his bid, he'll again come to the court saying he has no money.
Yes. Okay.
My lord, my prayer is, my lord.
And the
it
mohal
is
will hang, your
December,
lordship.
my lord.
Government loss revenue.
My prayer is December. No loss, my lord. No loss, my lord. My security money is lying with them, my dead rent, everything. 70 lakhs of rupees, no joke, my lord. First case money, entire money, plus security. That is lying with them. Why are they saying I am not running it at all? They should have inspected it. They have not done it. They should have passed an order. If at all, my lord, declining, my lord, rejecting my prayer. They could have done it very
You
well.
see, where a mining contract is granted, agreement has to be executed between the parties.
But that is the law. my lord.
Now, if it is not executed between the parties, then there's no mining agreement.
My lord. But on that, my lord, your lordship has to decide. For that, my lord, I'm making a prayer that the writ petition be disposed of because pleadings is conflict immediately, man. But only in the timing, my lord, 5 PM of today, my lord, is the last time, man. It will remain subject to the result of this writ petition. That is all, my lord, all I wanted. Otherwise, my lord, my IA will also be redundant. And my security man, it is not that, my lord, I have not paid. My security.
Let him participate in the tender process. In the
So if
meantime,
not allowed, if he
huh?
participates in that, in this tender process, again he'll come up saying I cannot pay the money. Because he.
Then he will be disqualified.
Whether it
He'll
is
be
pending before the
disqualified,
court.
subject to the
Yes,
decision.
my lord, that is what I
He'll
have.
be subject to the decision.
Very important.
He'll be subject to.
If my friend was here yesterday, my lord, it could have been done yesterday itself, this order.
Right, whatever I said.
Mr. R.R. Gogoi, Learned Standing Counsel Forest Department submits that no agreement has been signed with the applicant petitioner till today with regard to the extraction of the sand from the Dudhnoi River Sand Mahal.
In terms of. What is this? This is an act or a section? What is this? Act or rules?
Rules, my lord.
In terms of rule 22 of the
Minor mineral
Assam
concession.
minor concession rule.
minor minerals.
Concession rule.
Assam minor mineral concession.
Your first pages are gone. They're not here.
It will be Assam minor mineral.
Assam
concession-
minor minerals
Concession rules,
concession rules
2013.
2013. Next paragraph. on considering the fact that no, it's okay. On considering the fact that no decision has been communicated to the petitioner with regard to his application / representations for withdrawing from the settlement of the San Mahal and for granting an extended area and / or for granting an extended area. No, it does say and say or extending or granting an extended area for continuing with the extraction of sand. This court is of the view that the petitioner should be allowed to participate in the tender process for extraction of sand from the Domini. Full stop.
Domini River Sand Mahal number 1.
Domini River Sand Mahal number 1. Full stop. The selection of the petitioner with regard to the above tender process shall be subject to the final decision to be taken in WPC number 214 of 2023.
And the petition also, my lord, may be fixed, my lord, this petition.
First stop, accordingly. The IS is accordingly disposed of. Then you write in the main case. In view of the order dated today, 9/5/2023, passed in IAC 1176 of 2023. The petitioner has been allowed to take part in the tender process for extraction of sand, for settlement of
Domini River Sand.
Domini so. Subject to the outcome of the writ petition. List this matter on
Convenient.
25th of May.
25th.
Last prayer, my lord. This order, considering the time left, my lord. My friend can communicate, he can just give a.
Okay, Mr. Mr. R.R. Gogoi, learned counsel in the IA. Learned counsel for so shall communicate the contents of this order to the competent authority, to the respondent number,
DFO, your lordship.
to the DFO, where?
Respond number 5, DFO Walper.
To the DFO Golpara.
In this case, I need one week time, Lord. I need some instruction, Lordship.
9, 10, 11. Yes, till today you're not getting the information.
This is the 4 date. I have contacted the CDPO, Lordship. She has recently joined, Lordship. She will provide me, Lordship. I have talked with
When?
next week, Lordship.
Huh?
Next week, Lordship.
Are you sure?
Sure, Lordship.
Because, okay, I'm just right. Mr. N. Goswami, learned counsel for the respondent, submits that he will definitely provide the instructions required in terms of the order dated 10/4/2023. Full stop. It is noticed that the state respondents have taken enough time, have taken time. I have prayed for time on various occasions with respect to
the filling of the post, whether
the filling up of the post of Anganwadi worker in terms of the advertisement dated 8/2/2019. Full stop. It is made clear that in the event the said instruction is not forthcoming on the next date, the Director Social Welfare and the CDPO, Matya and the respondent number 5 shall personally be present on the next date at 10:30 AM. List the matter next week. When?
17.
You make sure that if they are not,
Lots.
if you don't have information, they have to be here.
Lots. 17.
This is the matter on 17th.
Bibliography.
Well, it is contempt matter, my lord. The notice was already issued on 2nd of November 2022, my lord. But there is office note, my lord, stating that the respondents, they have sent one letter to the Registrar General of this court, Honorable Court, but they have not cared to come forward, my lord. Neither any affidavit has been filed.
Huh? What?
They have sent one letter.
Who has sent one letter?
The contempt notice, my lord. There is office note, my lord. Wait, my lord. 16-3, my lord.
Yes.
Direction was to dispose of my application within three months, my lord. That is at page 37. And they have, they get activated, my lord, only in January. After 3 months has been lapsed, my lord. Then now they are saying that it's, as per the office note, my lord. They are saying that it's they are taking a decision.
Where is it said?
There is a letter, I guess, from General Joint.
What is the date? What is the date?
16-3, my lord. Office note dated 16-3.
I'm not talking about office note, I'm talking about the letter.
Oh, it is, let's go.
You look, you tell me. Next case, you bring the next case in the meantime. Yes.
I believe. My lord, my petitioner belong to a scheduled caste. His father is having also a scheduled caste certificate. But my certificate has been cancelled, lordship, without constituting a committee as provided by the apex court judgment, lordship, 1990.
Kumari Madhuri Patil.
Yes, Lord, Madhuri Patil. Only DC lordship, and that order was even not communicated to my.
Yes, madam.
And for respondent number 6, Your
Yes.
Lordship, I beg to file objection.
Lordship, may I please to
I
tell you,
before we stand, file objection.
I filed this petition in November 22. And repeatedly, lordship, from November 22, my learned friend is taking time. As per Madhuri Dixit judgment, lordship, the such writ petition. ought to
No,
be-
not repeatedly, Mr. Rao.
Yes, lordship.
You see, madam, it's a small thing. Now the only thing is whether your what caste certificate,
Yes,
huh?
yes.
Caste certificate. Whether it has been cancelled on the basis of any recommendation made by the committee constituted by the state government in terms of the Supreme Court judgment. That's all.
Yes.
We want to file written, we want to.
There's
file
nothing to file. You just call them up by phone. Talk to them by phone and tell them, you see, whenever somebody's caste or scheduled tribe status is under question, then the government has to constitute a committee as per the Supreme Court judgment. Now, his caste certificate has been cancelled by Whom, by whom?
By District Magistrate Lordship, Morigaon.
Where is that?
Page 30 Lordship. It itself shows that no committee was constituted. And that too when a complaint lodged by my adverse party.
Where is the caste certificate?
Yes, Lordship. Caste certificate, Lordship, page 18, 18.
Issued by whom?
Issued by Lordship, the Subdivisional Scheduled Caste Development Board.
Nothing, you see, it's all smudged. Huh? Everything is smudged out here, the seal. Show me the original.
Original. Original.
All smudged, nothing can be seen, nothing can be made out. You bring the original.
Yeah. Okay, Lordship, I'll produce it. But even my father is having the caste certificate, which has not been revoked.
Okay, your father, no, we don't know. But one thing is there, madam. DC has no authority to cancel a caste certificate. It has to be done by a committee formed by the state government in terms of Madhuri Patil. Show me the judgment is there. Which para?
I am having that.
Hey, just give me.
There are 13 there.
Para?
13.
13.
13 subpara 4 regarding constitutional committee.
So it has to be brought to the notice of that committee and that committee will decide.
I had flagged lot. Subpara 4.
So we won't disturb we won't disturb the cancellation.
Lordship, I am having the.
Yes, let me see.
Oh, I took father.
Father. We don't know if it has been made on the basis of the committee.
No, Lordship, the informed order shows that no such committee was constituted.
Hmm?
Page 30, Lordship, it discloses that no such committee was formed as per the decision of the Madhuri Parliament. Page 30, Lordship. That is sufficient.
Where does he say that? It may have been done, how do you know?
No, there must be a finding of the three-man committee constituted, recommended so and so. Nothing is there, page 30, annexure 6. Only ADC supported a report and he has cancelled district magistrate.
Your caste certificate has been issued by whom? Nothing is clear from here.
Lordship, I am having the clear copy by mistake for.
Show me.
Yes. And one thing, Lordship, when my father caste certificate has not been cancelled, how will become the non?
This also smudged out here. This seal.
Then I'll produce the original.
It says chairman. It doesn't even say DC.
So this was issued by subdivisional caste, scheduled caste development board.
Is this the authority who can issue a caste certificate?
Yes.
Huh?
Go approved by the government.
Under what law?
Under lordship, caste certificate, I think, order.
Show me that. Let us
Right
see.
now, I don't have that order law. But whatever it might be, lordship, in view of the Supreme Court.
No, you see, the thing is this. If the caste certificate has been issued by an authority who cannot issue such a certificate, then that Madhuri Patil is not required. If you go by the back
It
door,
will be countersigned by the ADC or DC, something like that.
additional deputy
Yes,
commissioner.
so it is to be countersigned by the ADC lodge.
Problem is, okay, when you're right. Heard, Mr.
SP Roy.
SP Roy. The learned counsel for the petition.
We need time to file objection, your lordship,
What objection?
because the caste certificate was issued on the basis of annexure 2 document,
Annexure 2, Page?
document, page 20, your lordship.
page
The
20.
document itself is not complete. We cannot rely on this
Some
document.
petition to start.
That's correct. I mean, I
It is-
cannot read. These are blank. I mean, what kind of a certificate are you
Yes,
issuing?
Proper.
That's correct.
Properly
We
Xerox.
need time to file objection.
I'll supply the original.
Okay, right. On the,
Fill up, your lordship.
correct. On the prayer of Miss
M. Nath,
M. Nadler, counsel for
respondent number 6.
respondent number 6, and Mr. N. Goswami for respondent number
1 to 5.
1 to 5, who are granted 3 weeks time or 2 weeks time, 3 weeks time to file affidavit in position. This is the matter. After 3 weeks, stop. The petitioner shall produce the original copies of page number 18 and 20 of the original copy of page number 18 and 20 of the petition. Yeah, unreadable,
I'll supply.
the certificate.
Oblige.
Item? Yes,
No, there's a flag mark A, B, and C, Miller. Flag mark A maybe is.
yes. So they have 1, 2, and 3. They have received.
Yes, they have received. They have not come forward, and my lord, kindly come, my lord may peruse the order, page 37 of the order, which we have alleged violation. And it's very clear, my lord. There is an office circular, office memorandum, my lord, by which everything is clear. They are not following that, their own office memorandum, my lord. Instead of they are saying that it's being sent to the, sent for cabinet decision, my lord. Page 37, my lord. May I read, my lord?
Yes.
In the present case in hand, no such move had been initiated from the Deputy Commissioner Dibrugarh, inasmuch the affidavit of the respondent number 3 is totally silent in that regard. In view of the stand taken by respondent number 3 in the affidavit in opposition, and considering the pressing need of the petitioners in order to complete the sale transaction, this writ petition is disposed of with a direction to the respondent number 3 to take steps as per government circular number so and so dated so and so, and after obtaining the necessary approval from the government. The sale permissions applied by the petitioners shall be taken up for consideration as per relevant law rules holding the field. Considering the plight of the petitioners and the respective prospective purchasers of flats commercial complex thereof, the said exercise of granting the sale permission shall be completed out within an outer limit of 3 months from the date of receipt of the copy of this order, along with a fresh representation from the petitioners or through their agents, authorized agents. So, my lord,
So where have they said that it is being considered?
they say in the flag mark A, my lord, they say that the cabinet decision is being taken. Likely to be put up, my lord. And Joint Secretary has instructed the standing council of the department to file an affidavit, my lord. In that very letter, my lord. In a contempt matter, perhaps this cannot be done unless they appear privately, my lord.
Okay, right. Heard, Mr.
Also provision.
R. Chakrabarti, learned counsel for the petitioners, who submits that the order dated 4/8/2021 passed in WPC 2789/2019 has not been complied with. He submits that though the respondents are aware of the pendency of this contempt petition, they have not deemed it not fit to appear in this court and have submitted letters to the registrar of this court with regard to the above order dated 4/8/2021, passed in WPC number 2789/2019. On considering the fact that the respondents are aware of the contempt petition and as they have received notice, this court is of the view that they should be represented either by themselves or through their counsel. Stop. So we issue warrant of arrest. Huh? Or it'll be too harsh in the first day.
Normally, my lord can do, my lord.
Huh?
This honorable court can.
No, can do. Can do doesn't mean that you take the harshest possible actions.
A bit harsh, yes.
A bailable warrant of arrest.
That can be done.
These are government officials, deputy commissioner and
Like Commissioner and Secretary, Revenue Department.
secretary and all this. Okay,
Yes.
we'll issue warrant of arrest. They don't want to come.
That's right, my lord.
Okay, right. As the order of this court has not been complied with
Lordship,
by,
may I, your lordship, lordship, I think 12. Lordship, name has not been reflected, your lordship. Mr. Gyanendra Dev Tripathi is right now he is the principal secretary of Revenue Department.
huh?
He is the principal secretary of the Revenue Department, your lordship. This contempt case,
Yes,
item number 12, your lordship.
yes.
In the respondent side column, your lordship, the name of the advocate is not reflected, your lordship.
We
The
will.
notice has been served or not, your lordship?
No, notice has been served. We know because the documents here prove it. They have written letters to the registrar.
Lordship, one last opportunity may be granted, your
This
lordship.
type of submission cannot be.
You are not
accepted by
their
the-
counsel. Okay.
You have to
Exactly, your lordship.
appear through an Okalatnama, my lord.
Just a
Not
minute.
like this.
Just a minute. Just
Lordship, usually what happens, your lordship, I am the standing counsel of Revenue Department. Whenever content case is received by any of the officers, they straight away they send a signed vakalatnama. Some miscommunication has must have been there, your lordship. One last opportunity, your lordship.
okay. That's for revenue. So we will not issue warrant of arrest. We'll issue for the deputy commissioner.
Yes, your lordship.
Deputy commissioner
Dibrugarh.
Dibrugarh and circle officer Dibrugarh. Pusto. Whatever I said.
As the order of this court has not been complied with,
and as the respondents do not deem it fit to appear before this court, comma, this court will have to take a serious view of the matter, comma, keeping in view that the case has been listed 5 times in their absence. Full stop. When there has been listed 5 times, has been listed 5 times. Full stop. Okay. Next paragraph. At this stage, Miss
And Bordello.
Ann Bordello
SC revenue.
submits that she may be given time to inform the respondent number 1
Yes, Your Worship.
with regard to the pendency of this case. As no, the pendency of this case. And she would revert back with regard to this case on the next date of hearing,
10 days time may be.
on the
granted.
next date of listing. Accordingly, come on, list this matter on when?
After 10 days, Your Worship.
Today's what date?
It is 9th, Your Worship.
9. List this matter on 19. 19. Full stop. No, make it 22. 22, huh? 22. Full stop. If we give time to revenue, why don't we give time to DC also?
Yes, Your Worship, there must be some miscommunication, Your Worship. Notice has been served on not.
But then there's no one appearing for DC.
Wakalatnama, Your Worship, I haven't gone through the records, Your Worship.
There is nothing, no vakalat.
Notice has been served on not. That's also not-
No vakalat. But there is a letter from the revenue to the Standing Council Revenue Department to take appropriate action.
Exactly, Your Lordship, the consulate hasn't reflected the name of the standing council or.
You have to
anyone,
give
Your
a
Lordship.
vakalat nama, madam.
Yes, Your Lordship, I think there is some.
There is no vakalat nama.
Or should I check up, Your Lordship?
And even for the deputy commissioner, copy has been given to the senior government advocate. By the DC's letter.
And I won't be able to reply, Your Lordship.
And even in the circle officer's letter, senior government advocate. What's that? Yes, what?
Lordship, we will communicate, Lordship. On the next date fixed, we will come up with some.
Who are you?
Lordship, government advocate, Lordship. Junior government advocate.
Okay, right. Mr.
Art Alukar.
R. Talukdar submits that he may also be given time to communicate the pendency of this case to the respondent number 2 and 3. And obtain and would revert back with regard to the same on the next day.
Deeply obliged, Your Lordship.
19, you bring something. Unless someone is appointed as a council, we'll have to be now harsh. Now we have given you time also.
I'm deeply obliged.
May it please your lordship. My lord, here in this case, what happened, your lordship passed an order. But unfortunately, without our knowledge, my lord, the designation of the officer was changed. When we produce the copy, then they say that there is no post commissioner and secretary. Now the post is on only secretary. So my lord, that may be amended, my lord, in my petition.
But then that is the name reflected in the designation reflected in your writ petition.
My lord, that is there, my lord. But thing is this, my lord, now without correction, my lord, they are not accepting the order.
Now
of your
can we
lordship,
correct this?
my lord? First title is to be corrected,
Now because everything is uploaded in the CIS.
my lord.
Otherwise there is no alternative because my lord, if I come with a fresh writ petition with correct name, res judicata will come. That's the problem. Because your lordship dispose of the matter. I am to come in the same way, my lord, again, which cannot be,
No, but one thing. Okay, for the state of Assam,
my lord,
you have said represented by the it should be
commissioner, my lord.
by the secretary,
Secretary, not commissioner, my lord.
not commissioner secretary.
Commissioner secretary, that is to be corrected.
So that word commissioner and may be cut. That's all. है ना?
Second, my
And-
lord,
and
your
the
lordship,
second-
your lordship B,
हाँ.
paragraph 3B.
No,
The
no.
additional chief engineer,
It cannot be paragraph
May be
3D, it
corrected.
will be the cost title, the addressee number,
no, my lord,
respondent number 3.
what is to be corrected, my lord, I have mentioned. Respondent number, paragraph 3 may be seen, my lord, paragraph 3B, now your lordship will see. Your lordship pointed out to me A, now B is this additional chief engineer. Public Health Engineering Department may be corrected and modified as the executive engineer. Executive engineer, public health engineering. And
Now
say-
everything will have to be changed, the entire cost title of the writ petition also will have to be changed.
Otherwise, my lord, I am not getting benefit of the lordship's order. Actually, it will not prejudice anybody, my lord. Their officer is there, but proper officer is to be addressed. Now your lordship C, sectional assistant to be corrected, may be corrected as sectional officer. That was, my lord. There nobody,
What to do, madam?
well, nobody will be prejudiced, my lord. That is why we are going to the officer concerned.
Yes, Mr. Gogoi, what is to be done here?
We don't have any objection, we correct it, but the lordship is like correcting the whole petition in a way, we're not changing everything.
Everything will have to be changed in the CIS. Supposing a fresh writ petition is issued, I mean is made with the correct cause title.
Cost titles.
My lord,
And-
if that liberty is given to me, my lord, then
No,
also.
I'm just thinking, and then because then, and you can say that this judgment, but then I think this is the correct way also.
Yes, my lord. And otherwise, my
Okay,
lord,
very
it
good.
will be a res judicata.
Okay, right.
If your lordship give me liberty.
No,
then-
no, right. We'll
My
see.
lord, your lordship, now your lordship will get this additional affidavit, my lord. I have filed
Additional affidavit?
in IA, my lord, because something was left out, my lord.
No, no, no. What do you mean?
I'm not
Then you
saying-
file a review.
That.
You file a review.
Well,
That will be better. If I've left out something, what
no,
have
my
I
lord,
left
that
out?
is also name of the, no, not left out, my lord. What happened, my lord, in the body of the order, that commissioner and secretary is there.
Naturally, because it's there in the
Yes,
cost
my-
title.
In the cost title, when cost title is sans, my lord, ultimately in the body of the order is to be sans.
Correct.
That is the thing, my lord.
So that
That
instead of
additional.
commissioner secretary, it should be
Commissioner,
secretary.
secretary, that chief secretary, that is the thing. Where it appears,
All your fault.
my lord, that is my fault, my lord, but it is blocked like anything, my lord. I cannot go other way, my lord.
Let us see what is the judgment, what changes
My
have to
lord,
be.
only judgment has been given that you produce this order before the. officer.
Commissioner secretary has to be changed.
Yes,
Okay, that's all. Commissioner and
that chief
in the
engineer,
2 paragraphs, that's all.
additional chief engineer to be executive engineer, my lord.
No, that is in the cost title.
Yes, cost title.
Don't mix up cost title and the body of the.
There are 5 and
Order.
there are 6. Commissioner
Para-
secretary is
that's all.
secretary.
Right. Okay, right. Heard Mr. M.A. Sheikh, learned counsel for the applicant. Is it applicant
Applicant.
who submits that the petitioner, that the applicant had made mistakes in the cost title of WPC number. Sorry about that, 5 minutes. WPC number 7473 of 2022. Come in as much as there is no commissioner secretary to the government of Assam, Public Health Engineering Department. And instead, there is a secretary to the government of Assam, Public Health Engineering Department. He also submits that the petitioner, the respondent number 3, that is the additional chief engineer, should be changed to executive engineer. Similarly, similarly, the respondent number 4 should be changed from sectional assistant to sectional officer. Besides the above, he also submits that a modification of the order dated 23/11/22 passed in WPC 7473/22 has to be changed in para 5 and 6, in as much as instead of the words inverted comma commissioner and secretary inverted commas close, the word secretary should be inserted. Full stop. Next para. The petitioner's counsel does praise that modification of the respondents in the cause title may be made as follows. Para 3 of the application, just take it down. Okay. Full stop. Next para, Miss
M. Kalita, Your Lordship.
M. Kalita appearing for
PhD department.
Huh?
For the PhD department.
for the PhD department, and Mr. R. Gogoi appearing for there is one. Submits that she has got no objection to the prayer made by the applicant's counsel. Full stop. Next, in view of the consent of the council of the PhD department, the cost title of the respondents, cost title with respect to the respondent numbers 1, 3, and 4 shall be recorded as follows. We take it down the second portion. Okay, it is here. Full stop. That's full stop. Further, para 5 and 6 of the order dated 23/11/22 passed in WPC 7473/22. Now, further the words commissioner secretary to the the words commissioner secretary, word commas, reflected in para 5 and 6 of the order dated so and so passed in WPC so and so shall be replaced by the word secretary. The application is accordingly disposed of.
My lord, another prayer before your lordship. Your lordship will turn to page 9
of
my IA.
Page 9. Yes.
Paragraph 6, my lord.
Yes.
So, my lord, I was directed to file this order copy to the commissioner and secretary. And commissioner, within 2 months from the date of receipt of certified copy of the order, PhD department is to do the thing. So we approached, my lord. Now what happened? That 2 months is already much over. So, my lord, from today, my lord.
Where is your prayer in the application?
My lord, that prayer is not there. Then I am to trouble your lordship again. Your lordship.
First of all, just right. Before that, you just right. In view of the modifications made to the order passed in so and so, the time period given to the petitioner for submitting a representation. For the time period given to the
authority, madam.
Respondent to the respondent number 1 to take a decision on the petitioner's representation dated 16/8/22 should be counted from the date of
From today, my lord.
Okay, from today,
My lord.
That it, the I is accordingly disposed of.
Must oblige, your lordship.
Yes.
View item number 15, your lordship, a date may be fixed, your lordship,
21,
25th, your lordship, this 25th.
25th. Let
Much
the
obliged,
matter
your
be
lordship.
as the prayer of the parties.
Lordship, in item number 18, your lordship, a mention has been made without taking any consent from us, your lordship.
What to do? I asked them specifically, have you spoken to the other side? They say yes.
No, without my consent, your lordship.
So that the problem is that your learned friends are lying to the court and to you, making a mockery of what to do. We do it on good faith.
But I must bring it before your lordship.
Yes,
So
I know. So from the next day, we will ensure that no adjournments unless the other side specifically comes on. Unless, of course, there are compelling reasons to give the adjournment. But what to do?
They have taken 2 weeks time, your lordship, without my consent. 2 weeks time after 2 weeks.
What to do?
A date may be fixed.
No, now we've already signed, it's already uploaded. Yes,
In item number 23 and 24, my lord.
Yes.
Interim orders were there, my lord. So
okay, right. List the matter after 2 weeks. Interim order passed today shall continue till the next week. Any interim order?
Item number 20 and 21, lordship.
Yes,
Interim order is there.
okay, same order.
20, 21. 22 is also there. 22 is also there.
Same order as the 23, 24. Huh?
Obliged, lordship.